Call to order. I'm Eric Greenberg, Chair of the CA Board of Directors. Please remember that this meeting of the CA Board of Directors is being live streamed. You can find tonight's agenda and background materials on the CA Board's webpage. Links to these documents can also be found in the description section of our YouTube live stream for those watching this meeting there. If you are virtual, please mute your microphones unless speaking. If you are in the room, please ensure that all cell phones are silenced. Raise your hand to speak and I will record the names in the order in which I see them. If you are virtual, please use the chat feature. As we move through the meeting, I will introduce each item on the agenda. Before a vote is taken, I will restate a motion as well as who motioned it and seconded. If at any point you have trouble hearing me or any other board member, please say so. Tonight's timekeeper is Alan Klein. I will now call the roll. Dick.
Here.
Lynn.
Here.
Brian.
Here.
Josh. Alan.
Present.
Dennis.
Here.
Why will this
Keith.
not-
Here.
Bill.
Here.
Andy. Ginny.
Here.
And I am here. Next, we have announcement of closed meetings and special meetings held or to be held. The Risk Management Committee held a closed meeting on April 13th, 2023 at 6:29 p.m. at CA headquarters. Committee members present were Susan Krabbe, Dennis Matty, Dick Bolton, and Josh Friedman. All Risk Management Committee meetings are closed under Maryland Homeowners Association Act, Maryland Code, Real Property, Section 11B-11144. Consultation with staff, personnel, consultants, attorneys, board members, or other persons in connection with pending or potential litigation or other legal matters. Therefore, no vote to close was taken. CA's Board of Directors held a closed meeting at CA headquarters on April 20th, 2023 at 7:08 p.m. Members participating at the June 23rd, 2022 meeting were Chairman Eric Greenberg, Vice Chair Virginia Thomas, Dick Bolton, Lynn Egan, Brian England, Alan Klein, Dennis Matty, Andrew Stack. The vote to close the meeting was 7-0-0, and the meeting was held April 20th, 2023. Members voting to close the meeting were Bolton, Egan, England, Greenberg, Klein, Stack, and Thomas. No directors voted against closing the meeting or abstained. The closed meeting was authorized under Maryland Homeowners Association, Maryland Code, Real Property, Section 11B-11141, discussion of matters pertaining to employees and personnel, and 4, consultation with staff, personnel, consultants, attorneys, board members, or other persons in connection with pending or potential litigation or other legal matters. Can I get a motion to approve the agenda?
So moved.
Is there a second?
Second.
Is there any discussion on the agenda? Any objections to the agenda? Seeing no objections, the agenda is so moved. We will now move to resident speak out. I'll call on you one by one in the order in which you signed up. Individuals have 3 minutes for comment. Anyone representing an organization has 5 minutes. Following remarks, the board will have a chance to ask questions. Please mute your microphones when you're not speaking. Our first individual is Sky Anderson. Sky?
Good evening. I'm Sky Anderson from Clary's Forest. First of all, at the next meeting, I'm going to be on the other side of the table. So the ethics policy is important to me. I believe CA and the IAT should split, should get a divorce. Now to my other topic. It's that time of year for boards to be elected or re-elected, and for board chairs as well. Many people think a chair is a leader. Nope, not so. A chair is a moderator whose sole job is to ensure that the minority has a voice. The most important person in the board meeting is each board member, not the chair. Comparing kindergarten to parliamentary procedure, a room of 5-year-olds is like a board of directors. To Forrest Gump, life is like a box of chocolates. You never know what you're going to get. At the start of a term on May 1st, you never know who the chair is going to be. So, vote for the chair who can keep the discussion on topic without veering off or descending into details. What are Robert's Rules of Order but the ones we learned in kindergarten? Be nice, take turns, don't be a bully, play fair. We practice what we learned, like, don't forget that you are never the smartest person in the room or the dumbest. You either know too much or not enough. Be prepared. Study your board packets so you don't ask questions that are already answered. And remember the Dick and Jane books and the first word you learned, look? Look at the person speaking. Don't fall asleep if it's a resident and you've heard it before. Take a nap every afternoon, especially on Thursdays, so you can stay up past 11 due to a needlessly long meeting. Kindergarten was long ago. What do I know now? A child can change. Even a board member can change. That's called learning. We can even change our vote if the chair has not yet announced the result. It does no good to tell 5-year-olds. Studies have shown that human society cannot function without an equitable distribution of resources. While this is profoundly true, we tell our 5-year-olds that there are 20 children in the class, but only 5 balls to play with. In board meetings, we take turns. Nobody takes a second turn until everyone has had a chance. The board sees to that. It's not kid stuff, it's not simple. It's elemental and necessary. Life is like a lab course. We practice these precepts daily and in each board meeting. It's true for kids and for adults, for schoolrooms and board meetings. I'm not finished, but I'm going to sit down now because my 3 minutes are almost up.
Thank you. Do you have any questions? Thank you. Next, we have Douglas Jarrett representing Moms Demand Action.
Thank you. Moms Demand Action is one of the several groups, anti-gun groups in the United States that have lobbied at various levels to, I guess, limit the distribution and availability of firearms. It's been an uphill struggle. Many of the members of the Moms Demand Action in Howard County have been at it for years, including my three friends over there who've done yeoman work for several years. First of all, I wanted to thank the board for putting on the agenda, the consent agenda, our request that the Columbia Association recognize this June 2nd, the first Friday in June, as National Gun Violence Awareness Day. It's going to occur, this is an annual event that started in 2018 when friends of a young woman in Chicago was killed. And on her 18th birthday, which was June 2nd, and I forget the year, they decided to initiate the custom of wearing orange on her birthday. And so it has evolved to the first Friday in June. The important thing to remember, I guess, about Wear Orange is simply that its purpose is to honor and remember the 120 plus people, U.S. citizens, that die from gun violence every day, and to express empathy for the survivors of gun violence. It's a sad and an unfortunate occurrence that hopefully events like this will get people to pause and think more clearly. There will also be events throughout the weekend in Howard County, including, among other things, a service at the Owen Brown Interfaith Center. The one last thing I wanted to ask and just request, and again, thanking you for putting our proclamation on the agenda, is one to allow us to illuminate Lake Kittimunde on June 2nd. And also, if we could make this first Friday in June a recurring event such that we don't have to burden the board every year with coming before you and making the request, as much as it's a positive for us because we get to speak to more people, particularly the leaders in the community. That's about it.
Thank you. Do you have any questions?
I do.
Keith.
One of the sorry. Okay. One of the questions that I had in terms of saying that you want this to be something that's annual versus, speaking at Resident Speak Out. It seems like in terms of disseminating a message, if you are here every single year to talk about and ask for that it might be more powerful than announcing something and then it gets parked away and then sure, we have this proclamation, but there's really never any
If you
visibility.
think, if the board thinks it's better for us to come in and renew, that makes perfect sense. We're not going to argue with it. It's a valid point, absolutely.
Thank you. Any further questions?
Well,
Jenny?
I didn't know if you wanted to comment on what you're going to be doing.
So I reached out to my team members, and we can make it happen on June 2nd. And then when you say Illuminate Lake Kit, you mean the area around it, not
Yeah.
the lake itself. So just to
Well-
be clear. Yeah, so we can make that happen.
Thank you.
I was thinking we're just going to do something like the Chicago River.
Yeah, that's only green in St. Patty's Day.
All righty.
Thank you.
Thank you.
Thank you. The chair also notes that Josh Friedman and Andy Stack joined the meeting at 7:05. Next, we have Chris Oliva.
I apologize for my tardiness. My Ravens tryout got canceled at the last minute. Don't know why.
Chris.
Hi, good evening. I just wanted to make a short report to you. First of all, you probably know that the Hickory Ridge Village proposal for the apartments has been affirmed by the circuit court, as would be expected, because the court is obliged to basically defer to and the legislative body, the zoning board, except under very extreme circumstances. Secondly, I just want to let you know the first briefings for the general plan have been done, and the county is moving away from their intent to go to the Guilford Industrial Center and turn that into a mixed-use center. And they're also reassessing some of their other considerations about what they wanted to do in Columbia. That's an ongoing discussion, which I'm sure you're all following in one way or another. Thirdly, I just wanted to thank all of you for serving. I know this is the last night for a lot of you, and it's a thankless job sometimes. And I hope that we can have less storm and drang in the future. And I hope that the new board and the staff will be neighborly and considerate of one another. So that's all I have. Thank you very much.
Thank you. Do you have any questions? Thank you. Next, we have Richard Bannister. Richard?
Hello. This is in partial response to the last resident speak out when a representative from the Columbia Association Watershed Advisory Committee spoke. First, since when did resident speak out become Columbia Association speak out? 2, the WAC representative claimed one reason for the Lake Alcorn project was because of, quote, continued erosion of streams is dumping untreated silt, nitrogen, and phosphorus into the lake. These components are causing the lake to have a buildup of not only chemicals, but of algae, which cover the surface for part of the year. The algae is not only unattractive, it can be dangerous. Filamentous algae grow near the pond edge and gradually float to the surface. It is unsightly and may interfere with fishing or other recreational activities, as well as lead to early morning fish kills caused by low dissolved oxygen. Blue-green algae can grow in lakes, ponds, and slow-moving streams when environmental conditions are right, including warm water, abundance of nutrients like phosphorus and nitrogen, and plenty of sunlight. Blue-green algae produces cytotoxins. The cytotoxins pose a serious threat not only to fish, but to companion animals and humans as well, close quote. As I have testified before, the nitrogen levels in the ponds and lakes of Columbia, according to CA's own documents, are normal year-round. Phosphorus levels only rise during storms and last just a few days. The key ingredient to produce high levels of algae is warmth. So, during the hot summer months, the algae get the warm water they need in order to thrive. Also, within the quote, it was pointed out that early morning fish kills are caused by resulting low dissolved oxygen. If toxic algae and low dissolved oxygen were concerns of the WAC, then the Lake Alcorn project would be the opposite of what they're supporting. Why? Because if warm water helps create the conditions for cytotoxins, then surely it would be best to leave a stream shaded by mature tree canopies and in shady banks where the water can remain cool. Removing those trees shading the stream that leads to Lake Alcorn, removing those shady banks and forcing the stream over sun-warmed dark rocks, which is how this kind of stream restoration is done, will only warm the water more. That warming will further deoxygenate the water before it even gets to the lake. And so the Lake Alcorn project will extend the time that Lake Alcorn is covered with algae and cytotoxins, extending the time of fish kills and danger to the public. The WAC don't seem to understand their own subject matter presented. Thirdly, I'd like to end with deep gratitude for the voluntary work that this current board has done for the benefit of all residents. Thank you.
Thank you. Do you have any questions? Ellen?
Yeah, Richard, I was just wondering, do you happen to have any data about water temperature rise in the Longfellow Stream restoration area?
You know, I don't. It actually brings up a point that Bill Santos asked me about the 2016 water quality report earlier in the, well, maybe even last year now. And I actually found the 2019 report, and that has water temperature and stuff in it. But, you know, on the website, on the watershed web part of the CA website, it says that these reports are supposed to be released every year. And it would be really nice if we could see what 2020 was like in 2021 and 2022, so we could actually see this data. You know, again, the watershed division is falling down on the work that it's supposed to be doing.
Thank you.
Thank you. Any further questions? Thank you. Next, we have Sharon Boyes representing Protect Our Streams.
This is a bottle of water from the restored Longfellow Stream. Good evening one last time to this board of volunteer neighbors. Thank you for your time and dedication and for patiently dealing with the drama-filled year. I would like to especially thank Ms. Thomas for her years of commitment and service to our community, our county, and our state, and Mr. England, not just for the past year, but for his decades of research, volunteer time, and advocacy for stormwater management reform and protection of our open space and our environment. Our group is opposed to the Lake Elkhorn Stream project. After listening to more than 5 minutes of textbook greenwashing by a CA committee during the last resident speak out, I must set the record straight. The WAC stated the reason they support this is because the continued erosion of storm streams, dumping untreated silt, nitrogen, and phosphorus into the streams, causing a buildup of chemicals in the lakes. That is exactly right. She said the nutrients can cause dangerous algae, leading to fish kills due to low dissolved oxygen. Right? She told you that slow-moving streams, warmer water temperatures, exposure to sunlight, and an abundance of nutrients, all four things which are a direct result of stream restorations, cause potentially lethal blue-green algae. This describes the stream in Longfellow, the headwaters to Wild Lake that now stinks at times, garbage in, garbage out. When it isn't safe for kids and dogs to play where it once was because of your actions, the degradation of water quality is a dereliction of duty. She discussed dredging costs. $7.5 million is a lot of money and would have bought a lot of rain gardens. But there's a dam. Does WAC not know that dams equal dredging, period? If you don't want to ever dredge again, remove the dam. If you don't want to have to dredge as much, then capture the runoff before it reaches the streams. And if you want to reduce the cost of dredging, buy or lease your own equipment. I have some figures, but apparently the WAC doesn't. Longfellow is proof these projects will not reduce the need to maintenance the lakes. She said storms producing stronger surges of stormwater runoff will cause scouring, erosion, deepening of channels, and trees to fall into streams. She's right again. But restorations don't control the weather or the upland stormwater runoff. When we allow runoff to erode, it will. Our geology is composed of quartz, mica, sandstone, clay. It's crumbly. That's why we need to collect the runoff before it reaches the stream. Reduced property margins and exposed infrastructure are bad side effects of runoff. They need to be repaired, but do not warrant 6 miles of destruction. The streams need a cure, not a Band-Aid. If the WAC wants to rehabilitate the streams, they need to file the watershed management plan on file with the Federal Register. She shared new information regarding the credits and the ruling in 6 months. There's a difference between TMDL and mitigation credits, and the board should demand all documents and communications between WSSI, CA, MDE, and ACE at this time to find out what she meant. We didn't say the plan provided is the final plan. We're waiting for the final plan. It's been confirmed that CA will have 10 days to get out of this contract without financial consequences once the plan is submitted. I pray the new board will uphold their obligation to protect the open space. I challenge the notion we need 50,000 rain gardens, and if WAC knew HOCO by design showed no plans for retrofitting our neighborhoods, how irresponsible is an advisory committee not to advise the board to take action on this gross oversight? I attended the meetings and commented on every single chapter. I fought for Columbia, but apparently the WAC didn't. Since she stated the contract has protections for the residents in it, I'm thankful she was asked for specifics, but when pressed, she didn't provide any. The residents should know about this project years ago, and all mature trees and most trees are important to the environment. How does bulldozing them rehabilitate anything? Talk to my neighbors about those protections. All in all, the greenwashing was disgraceful to hear, right down to the snarky comments about the wildlife. Less invasive deer would be nice, but how dare the WAC not be concerned about the loss of biodiversity and ecoservices, the aquatic species, migratory birds, reptiles, and amphibians, or that native flora is sometimes replaced with invasive species. It's shameful. Every single side effect mentioned is either a direct result from the restoration or will not be mitigated by allowing one. If you want a clean lake, less erosion, less dredging, and a walkable nature preserve, you need to preserve it. Please stop this project and address the runoff where it's occurring. It's that simple. Board members, it's your obligation to protect our open space, the forests, ponds, and streams. Thank you so much. Thank you for all your time over the past year, and very, very best wishes to each and every one of you.
Thank you. Do you have any questions?
Yeah, thank you, Sharon. That's very good. I just want to let you know that we got a new standard in Howard County, and it's been named after you. So when we're looking at a stormwater project, evidently, Deb Young said, well, will it pass the Sharon Boyce test? So I think it's rather good. So you've earned your position with all your testimony. Really appreciated all the technical side of your testimony. Thank you very much.
Thank you.
And thank you for your compliment to me as well. The Mutual Appreciation Society.
Thank you. Any further questions? Thank you.
Thank you, guys.
Last we have Amy Bennett. Amy?
Yes. Hi, I'm Amy Bennett, and I live in the village of Long Reach. I want to start off by thanking the board for the work that's been done over the last year. It's been a hard year for all of us. But in particular, I want to take a minute to thank Ginny Thomas. Ginny Thomas has been an ambassador for Columbia for decades. Her work, not only in the legislature, but also on the boards in her village.
Maybe you just move on to your testimony so you don't use any of your time. But thank you so much.
Well, only because you asked, Ginny. Okay, I'm here because I have spent the last probably 16 to 18 months participating or listening in on the Columbia Association Village Board meetings, or the Columbia Association Board meetings. And I'd like to share with you at least 3 observations that I've had and 3 areas that I'd like you to consider for further investigation for those of you who will remain on the board. And of course, we'll be coming back to the new board and raising some other issues. But the first thing I want to talk about is the granting of easements. I think it would be very important for the board to take, and the board and staff, to take a look at the granting of easements and whether that process is working the way you intended it to. Easements are granted very early on in most processes. I am not suggesting that all grant easement should have a more thorough review, but I am suggesting that there are times when a deeper dive into the granting of easements is important. For example, I believe that both the village boards and the Columbia Association board had a paucity of information when they granted the easement, for example, for Lake Elkhorn. That was a 7-mile project. It's a lot of land. I think there are times when when we need further description. I remember Dennis saying early on, well, when somebody offers you $10 million, you take it. Well, I think you asked for a plan. And so all I'm saying is, from my perspective, and I've listened to the granting of many easements over the last year and a half, is that you, as a staff and as a board, take easements. The second thing I want to talk about quickly is resident speak out. Resident speak out is required by the HOA Act and is an important component of Columbia Association. I was told by the previous board chair that when Resident Speak Out began, she glazed over because she was tired of hearing people whine. If that's your position, please get off the board. The last thing I want to say is that they're around Lake Elkhorn.
Your time. Could you make a final statement?
Yes, I can. You need to see the plan, and you need to know if 65 acres of trees are going to be downed. If it's not 65, what is it? And the last thing I'll say is never again allow communications between staff and the board to be cut off. Thank you, and thank you to everybody.
Thank you. Do you have
in the future?
Do you have any questions? Thank you. That concludes Resident Speak Up for tonight's meeting. To limit interruptions during board discussion and voting, all members of the general public will now be returned to the audience. This means you will no longer be able to show your camera or unmute your audio, but you're more than welcome to stay on as an attendee to watch the remainder of the meeting. You can also watch a live stream on the CA Livestream YouTube page. Thank you so much for your participation tonight. I will now take a moment to allow the staff to make this transition. Please remain. We'll take a break a little bit. Not right now. We'll do it after the discussion.
I think that's what it is.
Then you miss transition.
So they're, everyone that signed. You got the IP side.
Okay. Next on the agenda is the consent agenda. The first item on the consent agenda is the approval of the BOD meeting minutes from March 23rd, 2023. Seeing no objections.
Can I make a motion?
It's the consent agenda.
Right. So can I make a motion to approve the consent agenda?
Second.
I think that's just our procedure.
Yeah.
So why are we going item?
I'm just listing them all.
Okay.
Maybe you could read them all.
Yeah, I'm just going to read them all. Second thing on the agenda is the approval of the appointment of the representative from the Kings Contrivance Senior Advisory Committee. The appointment of Gene Bolton. The third thing on the consent agenda is the change to the Senior Advisory Committee charter and committee name, which will now be called the Aging Well in Columbia Advocacy Committee. And the final thing on the consent agenda is recognizing the first Friday in June as National Gun Violence Awareness Day. Seeing no objections, the consent agenda is so moved.
Just to be clear, it's June 2nd, 2023. We're not, at this point, making it an annual.
Yes, it's a 2023 proclamation.
Right.
So the first Friday in June 2023.
You have to keep coming back.
Yes.
We'll see.
Next we have board discussion, HRD institutional history, and I'd like to introduce John Healy.
Mr. Chairman?
Yes.
This was added to the agenda at the very last moment. We didn't get any background material on this. This is our last meeting of the fiscal year. Why was this done?
It's in the packet.
It was put in the packet hours ago. In the packet, this happened hours ago.
Anyway, we already moved the agenda, so the agenda has been approved.
I would just like an explanation. I'm not,
Well, we
I would
voted-
like an
voted
explanation,
on
please.
this.
Point of information. Why is this on the agenda?
We voted on this. We voted on the agenda.
That wasn't.
No, that's not an answer. Why is this on the agenda?
We asked for this at
Can
a
I-
previous board meeting.
Yes.
I don't recall that we asked for this particular
did.
issue.
We did.
If it was at a previous board meeting, it should have been put as part of the board ops committee. It should have been scheduled. It should
believe it
have
was
been
part of the
provided
board
to
ops
the public
committee.
a week ago. Why is this on the agenda at the last
I
minute?
believe this was from the, it was,
Bill, I think your point's been clear.
It's clear.
Clearly
I
made.
believe-
I believe we're probably going to end up moving forward, but your question probably needs to be answered more clearly.
Yeah, I believe this was on the board. I believe this was placed on the agenda originally by the board ops committee. Anyway, we'll continue. I'd like to thank you, John Healy, for agreeing to speak with us tonight. With the county moving towards rezoning, it's important to understand what makes Columbia special. This was emphasized by the testimony by the board from the River Hill Community Association on January 26th of this year. And to give a brief introduction, John was employed by James Rose for 8 years in the very early days of Columbia and is an expert on covenants, community planning, and real property law. John will help us understand the operation of covenants and rights of property owners in the planned community. So with that,
Thank you all very much.
minutes.
My name is John Healy. I'm a lawyer. Don't hold that against me. It happens in the best of families. I'm a HRD lawyer back in the 60s and the 70s. And some folks have asked me to come and maybe give it a little points on institutional history for HRD, and particularly, I guess, the legal philosophy and policy that we engaged in and what we did back in those days over at least a 10-year period of time that I was there. Community of Columbia, as far as we guys are concerned, we had 3 tap routes. And the first tap route was the single most essential, nourishing principle that all of us at HRD, and by all of us, I'm talking about lawyers, land planners, architects, construction guys, et cetera, we all lived and died by this first principle. And it came from Mr. Rouse. And I think anyone that knows Mr. Rouse or knew Mr. Rouse, he was a profoundly spiritual human being. And he believed strongly in the universality of humankind and their sources in all wanting the same results, the same virtues, the same values, the same of everything, all grounded in this notion of what a human being is. And from that principle, he took his talents and capacities, obviously in the 50s and the 60s, and came up with his dream to take his talents, monies, et cetera, relationships, and with the principle that everybody's got to live and work someplace, he decided, and he was a real estate guy, a finance guy, mortgage company, malls, he decided that he'd like to proceed with his dream. And as he assembled his apostles, as we guys called them, which would be a kitchen cabinet, his pals in the late 50s and whatnot, they came up with this concept of the community of Columbia. And the purpose, as I always understood it, working with everybody, was to do everything that we could as a development to enhance the nourishment and development of growth of everybody, be they homeowners, be they office building owners, be they retailers, whoever they were, in order to maximize their potential and their growth. This taproot, this spiritual taproot of mankind was our reason to be, our raison d'etre. And we use these kind of words. Our North Star. All debates, and we would have a lot of them, a lot of door slamming, a lot of files being thrown. You had no idea that when you get the disciplines of engineers coming up against planners who want serpentine streets as opposed to grid streets, planners who only want 4 banks in the town or 4 gas stations, et cetera, et cetera, et cetera. And the bean counters that are trying to make the budgets work and not work and where are we getting the money, et cetera, et cetera, et cetera. A lot of tension. But I can tell you all issues were ultimately resolved by this notion of why are we here? Who are we? And we use these terms of being a pragmatic altruist. Mr. Rouse was a pragmatic altruist as far as I'm concerned, and we were concerned back then. And it was just fabulous and exciting working for him. So this taproot, which was going to fuel us, which was going to guide us, which was going to steer us as we made all decisions. And of course, I'm going to be more specific on the legal side. We had to manifest it in some form, fashion, or another. And the manifestation of that dream was the people tree. And the people tree was so manifestly significant to help resolve tensions when we're talking about beans or streets or cemeteries that we had to move or not move or obeying the law and all the rest of it. Ultimately, it was always decided, well, what would the people want? What would a retailer in a Village Green want? What would a mall tenant want? What would someone who's a landlord and owns an office building and their tenants want? And that drove all of the decision-making. It was never money. Hard for folks to believe that, but it was never money. Money is oxygen. You have to have it, but it is not the beginning and the end of everything. And we were broke in the early 70s. We were insolvent in the early 70s. Again, why? The cost of building a village with serpentine streets and landscaping, and I could go on. I don't have all the time. I could go on and on and on. And the finiteness of every inch of the 15,000 acres was planned out, and it was expensive. Expensive to the point that we were insolvent and broke in the 70s. And the notion of the people tree, it's not a product, it's a virtue. And the notion of the virtue is that we were there for the common good. We weren't there for individuality or for any of us guys. And everyone sang from the same sheet of music. Believe me, we all sang from the same sheet of music. The second taproot, which was critical, was Newtown zoning, the ratios of Newtown zoning. Not Newtown zoning as zoning. We were living by Howard County zoning. We were not a town. We wanted to have nothing about it. We didn't want to have our own police department, fire department. We didn't want to have anything. We wanted to live under Howard County government. So all of the zoning uses and classifications and subdivision rules and regulations we complied with. We interfaced with them on a regular basis. But what was critically different was the ratios that the Newtown zoning produced that we wanted to have. And by ratios, I'm talking about what you all obviously must know, 10%, I guess it was, of the 15,000 acres was open space land. A third was residential property. We even broke down the residential so much attached, so much detached, so much apartments, condos, blah, 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 blah. And on you go and on you go, so that we had all these percentages for the various uses that we were going to have. Open space, residential, commercial, et cetera, et cetera, et cetera. Those ratios critical to our vision, Mr. Rouse's vision of what the community of Columbia would look like 25 years out. Once we build it out, we're going to have 100,000 people, give or take. But the balancing of these uses that we wanted to have was the ratios. And even within those ratios, we were going to be very, very restrictive in terms of how we were going to implement it. The third tap route was the covenants. We knew as attorneys under the law that zoning is nothing but regulatory, as opined by the Supreme Court of the United States in the Euclid case going into in the 20s, I think it was, and as articulated by the Court of Appeals of Maryland, which was then the highest court, and now named as the Supreme Court. Zoning is nothing but regulatory. Nobody has a vested right in their zoning until they act upon it. Once they act upon it, there's nothing you can do about it. But we also knew we had a 20, 25-year project, and we were not naive about the sensitivity of the political whims of the populace in the county. Not everybody liked us in Howard County back in those days. It was Columbia versus non-Columbians, and that story could go on forever. So how were we going to satisfy that new town zoning ratio would be etched in stone? Etched in stone. It was through the covenants. And we promised everybody that came to Columbia, everybody that walked through the exhibit center that wanted to buy a house, all the builders, the Rylands, the Columbia builders, et cetera, we promised everybody that when we were finished, the city of Columbia would look like this. And we would have a hospital there, and we would have a school here, and we would only have 4 gas stations, and I don't know whether it was 4 or 5 or 6, and so many banks and whatnot. And how were we going to make sure that happened? We had 2 problems. Zoning could change on you. The zoning board in the New York second could change on you. The populace could change on you. That was a big issue. And how are we going to guarantee that it's going to look like that in 20, 25 years? It was the covenants that we put in place. Now, the covenant came about from the days of the Magna Carta. And once you record a covenant, any covenant, with the land in the record room, it runs and binds on the land in perpetuity forever. You cannot get rid of it, but for 2 ways, which I'll tell you. You can't get rid of it. And there is nothing that Howard County government today, zoning board today, General Assembly in Annapolis, Architectural Committee, HRD today or then when I was there doing it, even Mr. Rouse himself could not abrogate the covenants that we had recorded. Impossible legally. Those covenants trump everything. Having said that, I'm sorry, I'm at 5 minutes, and having said that, there's only 2 ways you can get rid of a covenant. Condemnation, and the government that goes ahead and does that would have to compensate everybody in the community of Columbia, all 15,000 acres of ownership, including their lenders, because we're a title state, and compensate them for that condemnation process. Or all the parties that are subject to the covenants unanimously would have to get rid of the covenants if they were going to terminate them. Or, and I forget, in the covenants we used to put in, I don't know, it was 2/3 or 75%, if you wanted to moderate them or mend them or change them or make them go in some kind of a direction. A month ago, I was asked thereabouts, what would Mr. Rouse do, in my opinion? Given changing of the times, signs of the times, 2023, demographics, dynamics, I don't know. And I said, well, I can tell you what he wouldn't do, and I can tell you what he would do. And I can tell you how I know he would do what I'm about ready to say. First thing he would never do is abort the people tree. He would never abort his dream, the people tree, the covenants, not in a million years, ever. Ever. What he would do, if the dynamics of today motivated him, he'd go out and get another 15,000 acres. And how do I know he would do that? I know he would do that because he endlessly evangelized us to go out and evangelize the People Tree. So Len Ivins, who was the town manager at the time, he took off of Mr. Mitchell and went to Texas, built the town of Woodlands outside of Houston, took the People Tree with him. Jimmy Wanamaker and George Sheehan went to Rochester, New York, and the Beta Shoe Company up in Harford County took the People Tree with them. Joe Tipperman and myself, we were hired by W.R. Grace, 7,800 acres, Swedesboro, New Jersey, right across the river from Philadelphia. We took the People Tree with us. Barry Oxford and myself, we're Rausketeers. We all considered ourselves disciples and Rausketeers compared to the inner sanctum of the apostles. We went to Nashville, Tennessee, did 2,800 acres in North Nashville, Tennessee, called Metro Center. Mr. Rouse wanted us to carry into the United States of America the People Tree. That real estate was not for just making dough, making money. It was to create a place where people live and work and come and visit and nourish them spiritually to be the best they can possibly be. So what could we do as land developers or builders to enhance that process? And that's who we were. At least that was who we were until I left in the 70s, for crying out loud. And everybody in the community, the Rotary people, you name it, everybody, it was a massively exciting time and to work for Mr. Rouse. So for whatever that's worth, I don't know. I'm 84, so I'm long gone. All I wanted to do is snuggle with my wife at night and have a cup of coffee in the morning. You know what I mean? Walk around a block. I don't know what's going on, but that is the way we were, and we were intolerant. Legally, we were intolerant. We promised people, and we put it in our contracts of sale, we put it in our leases, we put it in our deeds, we put it in our covenants. Nothing to be discussed. And the real property principle is known as the negative reciprocal servitude. And that's what you have in Columbia, both horizontally the covenants and vertically the covenants. And that's where it was, at least all the time until I left. Initially, it was builders and their lawyers, they thought we were being kind of draconian, and we would say, yeah, you got it. You all may think you own your piece of property, but you don't. We're going to tell you what you're going to do with it, when you're going to do with it, how it's going to look. You want a green door on your house, you're not going to have it. We want hawthorn trees here. You all have no idea how finite, inch by inch, the planners and the architects and the lawyers and we guys, how we drove that thing back then. So that's my story, and I'm stuck with it.
Thank you. Do you have any questions? Ellen?
Yeah, I will say that whoever's decision those sweet gumball trees were, that was a horrible decision. Oh, yeah.
I was a lawyer. I didn't have anything to do with landscaping.
Do the covenants allow for development on open space? I mean, could we, for example, could we convey our open space for development?
Ginny?
I mean, it's clear to me. To me, this is 101. This is 1 + 1. I don't know what they teach anybody in law school anymore. As I was winding my way out of practice in law, I swear to God, they all go and get their money back. But the way we got all drug up, I mean, it was blocking and tackling. 1 + 1 = 2. And my job is to keep Mr. Rouse and everybody out of trouble.
Thank you.
Ginny?
Yeah, two questions. To add on to what Alan was saying, you said no to we can't allow development on open space, but in fact, don't we have development on open space if it's certain things like recreation?
Well, as to that issue, when the gentleman said development to me means real estate development. If you're talking about open space plus all the improvements made on open space for the benefit of the community, like a swimming pool or whatever, that's fine. I don't consider that development in the context of the question.
So, with that, it's talking about CA basically in Columbia. But if a private sector developer wanted to, profit developer wanted to build and work it out with CA. I'm not saying this is happening, but for, I don't know, something that they thought would benefit and were saying would benefit a lot of people, and put it on our open space and,
Can't do it. I say you can't do it. Why? Conceptually, CA, as far as we were concerned, is a management company. It's not a homeowners association. Whether or not that got changed somehow legally, and assuming they did it correctly, I don't know. But the bottom line is that CA was a management company for us. And then when the time was to come that it got turned over to the village folks, when that time would come, however you view yourselves and however you label yourselves, you're trustees. And under a trust concept, the corpus of the trust is the open space and the assets that are improvements that are built on the open space lots. And the beneficiaries of the trust are the people of Columbia.
Okay, just two more things. One, though, through easements or licenses or settlements or something, could you allow a contract, allow a private sector profit organization to do something with your land? That
is a much more sophisticated and difficult question, and the facts would drive the answer to that question. So if I was still practicing and you're part of CA and you come to me and I represented CA and you asked me, I'd have to look at the whole fact dynamic as to whether I would say you could do it or you couldn't do it.
Okay, so it is somewhat possible. Okay, the thing you said originally though was, the whole percentage thing on how Columbia was.
The ratios, yes.
Right, and I was on the zoning board in those days, so I know what you're talking about. But you also said the ratio is etched in stone through the covenants.
Yes.
Right?
Yes.
All right, so explain to me then, or help me understand, if the county wants to, if we've achieved the number of residential units, say, and I know they're broken down to different ones, but, and the county's saying, boy, we need more residential.
Can't do it.
Well, wait. We need more residential.
I'm worried about my timeline.
No, your time's over. I mean, you're finished. I'm teasing you. This is on our time, so don't worry about it. Yeah, don't keep looking at the clock. It's not going to get any better. It's 0, 0, 0, 0. So if the county is saying we've got to have more development, I mean residential development, we need places for people to live, and yet the percentages have been met, which I always thought in those days was sacred. Okay. So how is the county then looking at, since you're not going to develop much in the water, where you don't have water and sewer, how is the county thinking about increased development in the village centers or other areas? How can they do that?
In my professional opinion, they cannot. If the ratios have been exceeded, as was etched in stone, as I say, and the stone etching is the covenants, and the covenants that I talk about are not only horizontal, like the CA Lane, all of Columbia, BG&E, we've got BG&E easement over all of Columbia, and then the village covenants. Those are what I call horizontal covenants. The vertical covenants were where we continue to restrict the uses that the piece of property would otherwise have pursuant to Howard County uses, but we, as the developer, privately said, and I owned a building in Columbia beyond the hospital, John, you can build an office building there, but the use would permit me to have a bank, but you can't have a bank. So there was like 7 or 8 uses I was entitled to under the zoning for the piece of property behind the hospital, but under the contract and the deed and the covenants, can't do it. You're stuck. Why was that? Because the ratios were critically important to us.
Yeah.
And all over in Columbia.
Okay. Last question. Can state law oversee that?
I'm sorry? No.
Okay.
That's the ironic. What is so simple for me is the covenant trumps everything. There is no governmental authority other than condemnation.
Dick?
Those ratios,
They're based on acreage, though, aren't they? They're not.
I couldn't tell you, I didn't put them all together. Meaning I was not the author or the landscapers or the geniuses that said, we want to have 1,500, let's say 10% of CA. Somebody came up with 10% and figured it out, it was 1,500.
What I'm asking is,
Give or take, I don't know.
if you have a percentage for housing, let's say,
I'm sorry.
if you had a percentage dedicated,
Yeah, it
committed
was
to
about
housing.
30, it was like somewhere around 30 if I remember.
Yes, but it wouldn't be how many units you had, would it? Wouldn't it be how many acres, these acres?
No, when I say no, I don't know. I can't answer the question. You get Wanamaker, I understand, still alive, and he's up in Pennsylvania.
Okay.
You could get him down here, and he could answer all those questions.
Okay.
But on the I can only answer on the legal side. The legal side is real simple to me. What I've just said, you can't do it. Nobody can do it. Only government can condemn, and only the people that are subject to the covenant, only those folks and their lenders, because Maryland's a title state, they all have to join in and determine. So if you want to get rid of Wild Lake Village covenants, you'd have to get everybody, and we did that.
No, I was just wondering what units apply.
Okay, Dick.
All right, thank you.
Anyway, we're at time for this segment. Assuming there's.
Ginny asked 12 questions.
Do you have a question?
I have plenty of questions.
Well, then raise your hand. Good.
Okay, here we go. Just to let you know, thank you, Mr. Geary. I come way of George Barker and Bob Tenenbaum. Before they passed in Wild Lake, I spent many evenings talking with each individual, and I've learned a lot from both of those guys. They're pillars of this community. And I know George personally. He was a great man. When you talk about covenants, I'm aware of village covenants, CA covenants, and the employment commercial covenants. Are there any other covenants that you're speaking of? If you went down the land records, I just gave you one example. If you went down the land records and pulled all of the non-residential deeds, you're going to find vertical covenants, but at least as long as I was there for 10 years. Okay. Now, if I can, I think what you're referring to is what I've heard from George and Bob, if I can call them that, Mr. Tenenbaum and Mr. Barker. You're talking about deed restrictions, are you not? Yes. Okay, because there are not as many as you would believe. I have looked in all of Wild Lake, and for instance, there is a fantastic deed restriction on the Wild Lake Village Center, which says that you cannot put a discount store in there. That's in the deed, it runs with the land, so if heaven forbid we don't have our grocery store there anymore, a dollar store cannot open up there. That is correct. So that is part of the deed restrictions. But they don't spell out the specifics of acreage for percentages of open space or employment commercial or residential. They specifically restrict uses. I agree with you there, but they don't spell out a grand plan. That only occurs in the zoning, is that right? All right. Where that is correct. But in addition to that, the overall overarching, what we call in real property legal principles, that go back to the I'm not kidding when I say go back to Magna Carta, is a negative reciprocal servitude, AKA commonly known as a scheme of development. So the covenants within and under that umbrella may or may not change. The covenants themselves, Village Green, Oakland Mill, blah, 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 they may have some mutation. But the overall scheme of development of the city comes under negative reciprocal servitudes, which is known as a scheme of development, which has been authenticated and authorized by the Court of Appeals of Maryland. And where is that written down? Where is this scheme of development that you speak of? Where is it? Yes. It's Columbia. It's the effect. It's the result. And what you have to do, if you were going to litigate the case, and the cases have been litigated, you would go before the court because someone's going to be saying to you, well, there is no scheme of development. You cannot impose upon me your covenant because there's this nuance. There is this change. And then I would be saying, no, it's a scheme of development. All of Columbia was intended to be the way it is at the end. And then we'd litigate it, and the facts would come out, and then the court would say, oh, Healy, you're right. Or Healy, you're wrong, et cetera, et cetera, et cetera. Okay. But everything is so fact-driven when you get to the kind of questions that you asked or you asked, ma'am, about, what can, like that. The easement issue, it's very fact-driven. But the principle of what the poker game you're playing remains the same It's irrefutable.
So you're just saying it's not written down anywhere? It's a general scheme?
It's in court cases. It's in the opinions of the Court of Appeals of Maryland.
Okay, can you please, are you finished?
For Columbia, it's the PDP.
Thank you. Thank you.
That would be.
Anyway, we've got a fairly long agenda.
Which is why I question why this was put on the agenda at the last minute.
And then you took 20 minutes. So assuming there are no further questions, I'd like to thank you for coming out.
Thank you very much.
And now, can we take a 15-minute recess? 15 or 5? 10 minutes. 10 minutes. 10-minute recess. Convene at 8:10.
Okay.
Just concerned, we have a very long agenda, and we just took a 15-minute.
So the first item on 7A is the Ethics Code. The chair moves to establish the new Code of Ethics, which replaces the Code of Ethics in Business Conduct, the Conflicts of Interest Policy for Senior Management and the Board of Directors, and the Code of Ethics and Business Conduct and Conflicts of Interest Policy special requirements for members of the Board of Directors. Can I get a second for the motion under 7A? 6 seconds it. So we have several amendments to this motion, and we'll go through them one by one. We'll vote on each amendment. When those are all done, we'll vote on the main motion.
Can I make a general statement?
Sure.
So what I'd like to say is that this is incredibly complex, and it shouldn't be, right? We had a policy that everyone here signed that was a good policy, and we agreed that some amendments had to be made. And we went through and made the amendments. Outside counsel, inside counsel, different councils, all agree with what they should be. And then we came full circle. We agreed to it. We changed it. It seems like we keep running around in circles on this, and it is so incredibly, to me at least, and I've spent a lot of time, and staff has spent a lot of time on this. And we're at the final hour, right? Where this is the last meeting. And my recommendation is that we take this stuff, we take this packet that we have tonight, and let the new board that's seated on May 11th sign the existing policy, and then turn this packet over in its entirety to the new board. And if they want to make changes, let them make changes at that time. But we have a good policy with some exceptions. It's a living document, but I'm not sure at the 11th hour. And we have spent, it's only been me for 2 months, but this board has spent an incredible amount of time on this.
So are you moving to table the ethics policy 7A?
I'm moving to table the entire discussion on the ethics.
Well, we're on 7A.
Okay, on 7A.
So are you moving to table the motion?
Yes.
Yes, so we got a motion by Dennis to table the ethics policy. Do you have a second on tabling it?
Sure, I'll second.
So, so we got a second on tabling it from Andy. So do we have any discussions on tabling the motion?
Yes, we have been dealing with this for 6 years now. We have had a lot of discussions, The existing 4-part code or whatever it is a mess. And it needed to be simplified, cleaned up, made easier to read. And after a lot of work by members of the board, by our lawyers, by everybody, we've got a pretty good plan here. I think we have a very good plan here. It corrects a lot of the problems that we have had. And to stop now and kick the can down the road just doesn't make any sense. I think we are 99% of the way there. I don't want to have the next board have to start all over again fooling around with this thing. And the current code is really unacceptable. And as I said, for 6 years, we've been trying to get this thing done. I'm sorry it waited for the last meeting, but I do not want to table this. I want to move ahead, discuss it, and see if we can improve something.
Any further comments on tabling? Ellen?
I guess, I don't have a comment, I have a question. If the rationale is we spent so much time, I'm totally unclear why spending more time, because the new board would have to come up to speed and so on. I don't.
Dennis?
Because what's proposed goes against the advice of outside counsel.
It was prepared by outside counsel.
Not so there is a code, can I keep going?
You can keep going.
What is prepared before the amendments that were made. So there was a code that we had, a policy that we had, that we then amended by outside counsel, and then it was further amended by other parties, and then it was revised again, and now we have more amendments in front of us that are not recommended by outside counsel. So we don't have concurrence, I don't think, among this group, or certainly among the council that we've had review it.
One person at a time.
Okay.
Do you have a follow-up
Well, I'm just,
And I'll get Josh.
Okay.
I'm not clear how that changes in the next board. There would still be disagreements, there would still be amendments that are being recommended. What do we get by?
Hold on, I need to say this because we could get sued if this discussion continues.
Huh?
To say in a public forum that we are acting against the advice of counsel is a huge liability. And if we're going to discuss advice that we've received from counsel, that needs to be done in a closed session.
Can I get counsel's advice on the comment?
There are, well, I'd take a step back. One, there's a lot of work has gone into this. It has, in fact, simplified, cleaned up, and made it easier to read 3 different policies, but there are 4 currently. I don't think it's appropriate, and I don't think it's privileged just for me to have this conversation. I don't think it's appropriate to adopt this policy until the enforcement policy can be adopted at the same time. I think it's appropriate for this board to say, we've worked long and hard on it. We approve this in the form that it's in to be implemented when the enforcement policy is ready. That's going to be the product of the next board, and the actual adoption and implementation of this policy is going to be done by the next board. Because there are references in this combination of 3 of 4 pieces of your policy to things that don't exist in your enforcement policy. So that's the next project, is to revise that policy to work with this one.
So
On the point of privilege, though,
I'll go back to Alan and I'll get Bill if there's a
On the
follow-up
point of privilege,
to Alan's
though.
comment.
is there a difference between getting legal advice and getting, I'll put it in lowercase, expert ethical advice from somebody who happens to be a lawyer?
So ethics.
Story of our 6 years.
Yeah, that's really interesting. I mean, we all can reflect back on, philosophy 101. Ethics is not a set of, I guess certain philosophers would say, we know what true ethics is. Most philosophers would say it's somewhat contextual. But there are certain rules that apply to you as a board that are in the law. I'm not answering your question. Ask me your question again. I'm sorry.
Well, I'm hearing Josh's point of privilege being, what the heck are we doing in open meeting, getting advice from an attorney without us deciding that this is open forum, open season? So, and I just don't know. And if you happen to be an expert on ethics who had been trained as a journalist and weren't an attorney, then we wouldn't have this conflict. So I just don't know. I really literally don't know. Can you give us advice that's not legal advice, but is coming from your position that I'm going to assume you have as an expert, however that's defined?
So if I were to give you advice about a specific set of facts, the application of the law to that set of facts in a context where I was advising you about the implications of the law in a context where we both expected it to be confidential, that's giving you advice that's privileged. And I'd waive the privilege were I to do it in a forum like this. I'm not going to...
But it's our privilege, isn't it?
Well, you would be waiving the privilege if we had that conversation. Yes, it's your privilege. But we're not having that conversation here. We're talking about a set of guidelines that you as a board are considering. And I don't think I'd consider it confidential to tell you where I think that's consistent with the law or inconsistent with the law, because we're not talking about a circumstance that you're engaged in.
Okay. Bill?
I think we need to recharacterize this a little bit. This is not going against legal advice. This is amendments that have not yet been vetted by anyone. And that's what the concern is. It's not whether it's going against an attorney's advice or for an attorney's advice, whether that is privileged or confidential or not. We have amendments that haven't actually been vetted. And the intent, I believe, of the amendment was to vote and pass these so that they would become part of the policy without having that vetting first. We should have something that says that these are consistent with good ethics policies and within the realm of the law. And that's the concern, is that these amendments have not been vetted yet. I think that's where we need to be.
Jenny?
Yeah, maybe I misunderstood Josh, but I thought what Josh was saying is we should not be saying that we are going against the advice of counsel.
That is exactly what I'm
Because
saying.
I don't believe I believe we have heard the advice of counsel and it's our advice of somebody else, et cetera, and we have a right to make a decision. I also am not clear on whether we really should have waived confidentiality as a board, which we did not do, but that's a separate issue, I guess.
Dennis?
So I think the Venable report was read into the open record, Jackie, and I also think that Wes was here in meetings and discussed this in open. This was all in open meetings. This was not done in closed session. The things that I was discussing, this was done in open sessions.
Was the Venable report read in open meeting? I don't know.
Parts of it were.
Parts. Okay, see, that's where you get into trouble.
I don't.
I was told that there were recommendations made in the Venable report and that those were shared.
That's correct.
Those are
Yes.
essentially part of
But
the
there was a
public record.
closed meeting on that first.
And I think they go to
They're both.
the contents of a policy, not to application of the policy to a specific situation, not to any specific charge or investigation.
Keith?
I think the point's been made, and I don't know that there's anything to resolve. We can talk about this, but I think what we're saying is that we said some things in terms of positioning, and we just need to move forward discussing the items that are here. If we continue to talk about legal opinion, then we could potentially get ourselves in trouble. So if we just avoid that and we just discuss the items that are on the table, it seems like we should be in good shape. Dick?
And if we do that, I would suggest that the lawyer not be part of the conversation.
Why wouldn't the lawyer
Because
be?
then we get into the question of legal advice.
Well, I'm a little confused there because the legal advice. So, and correct, please step in if I'm wrong here. But where you get into issues of confidentiality is when you're dealing with a very specific circumstance where you want to protect the confidentiality of that particular circumstance, whether it's person, places, something that you don't want to get out. But the ethics code is going to be public one way or another. So, is there a confidentiality when you're talking about the legal application of a code that's public anyway, and the law is public?
I think you're fine having the conversation about the terms proposed. I think if I see something in the terms that are proposed that is inconsistent in some circumstances, could be inconsistent, let's say, with law, and I bring that to your attention, I don't think that's necessarily privileged. I don't think you should, you've heard that advice where I'm going to give it. You've heard it several times. And it really, I guess, relates to an amendment, I think, that's proposed. And again, that's the difference between ethics and the law. And I'm going to tell you, ethics are in the eye of the beholder. You can adopt a policy that you like, but I'm going to point out to you where at least what is going to be discussed in one of the amendments, I think, is simply not consistent with law to have a bald statement that something's not a conflict. So, and I just don't think that that's a particularly privileged. If it is, it's in the public record already. That discussion is out there.
Keith, can we get a statement on this motion and then allow us to vote on it? Because we opened up the First Amendment. Is that correct?
Well, there's a
No.
So
Okay.
well, you not open up the First Amendment. The motion to table takes priority. So right now, the motion on the floor is to table the motion on the floor is to table the motion as read by the chair. As moved by the chair.
Which is 7A.
So right now, there's a motion by the chair as written to move the new ethics policy, which was seconded by Dick. And there's a motion by Dennis, seconded by Andy, to table the motion as moved by the chair. So that's where we are now.
Clarification? We're just talking about 7A right now.
Yeah, 7A. So you have to table them one at a time.
Thank you.
So
I'll just say this about tabling, and I'm going to vote against tabling, and I appreciate that this is basically a lame duck session of the board right now. But here's the thing about this policy. Ultimately, it doesn't matter if it's the next board or a board 10, 20 years from now. The only if there's a problem, the only way to punish a director for misconduct is to remove them. And it doesn't matter what we pass tonight. The next board, every other board in perpetuity, ultimately has that decision to remove a director or not remove a director. So they're still going to have that freedom. We're not tying the hands of any future board by voting on this tonight. So I am going to vote against tabling, and but I appreciate those who have deference for our next board.
Any further questions on the motion to table? Actually, I do have one for Dennis. So last year at this time, we had actually the same motion on the table, different policy, but we literally had the same motion, and there's the same motion to table that motion. The motion to table passed last year at this time, and then we wound up with 1 year of literally having tons of meetings and ethics policies revisions, board revisions, et cetera, et cetera, et cetera. So the question I have is, if we table this tonight, how do we prevent the next board from going through the same thing, occupying all the next year, writing, rewriting, redrafting
You don't.
the ethics policy for the next year and running into a circular loop?
You don't.
So he's asking if you want to withdraw your motion to table?
I wasn't asking, I was just wondering how we get out of this.
Are you willing to withdraw your motion to table?
Yes.
Okay, the motion to
Thank you.
The motion to table has been withdrawn.
Thank you.
Okay. So that leaves us with
Ethics code.
That leaves us with First Amendment, moved by the chair to retain the current conflict of interest verbiage from the current policy, replacing section 5.0 in the ethics code with 5.01 financial conflicts of interest definition. Just take the text from section 3 of the current conflicts of interest policy for senior management and the board of directors. So this is actually using our current conflict of interest policy and putting it into the new policy. And also 5.02, procedures regarding disclosure, review, and handling of conflicts of interest, using again the text from section 4 of the current conflict of interest policy for senior management and the board of directors, and also replace the body of 6.03 in the new code with the text from section 4 of the current code of ethics business conduct. So basically, this amendment takes the current conflict of interest policy, which we've all signed, it's in all our codes, and just brings it into the new code. So we're just moving the current conflict of interest policy that we've all signed and moving it forward. So that's the motion by the chair. Do I have a second for the motion?
Second.
Second from Keith. Do we have any discussion on Amendment 1?
I was going to second.
Okay, any discussion on Amendment 1? Andy?
Yeah, my difficulty with Amendment 1 is one of the things we wanted to do when we updated the policy was to clear up some of the discussions that have occurred over the years on conflict of interest. And by using the same language we currently have, we continue to have the same problems. One of the things that I noted immediately was that in the updated language, I'll call it, it specifically states that a conflict of interest does not have to be financial. Okay, it doesn't have to have a financial component. If you look at our current, the conflict of interest is actually titled financial conflict of interest. Okay, and what previous people have argued is that then conflicts of interest only have a confidential,
What?
I only have a.
There seemed to be a live mic. Continue. Sorry.
Only have a financial interest. And this makes it more clear that a conflict of interest can also, does not have to have a financial component. So I think that's one of the things that I like about the updated language versus our current, because I think it's really important to kind of stress that, to get people to understand it up front. I also think that it removes the language which states that a board member will refrain from participating in the deliberations and voting when determining if a conflict of, the conflict of interest and that. And once again, I think that's important language that is not in our current policy. And once again, that clears up areas that have been discussed. And so I really think we need to go with the new language, particularly for the conflict of interest, and not use the old one, because that's why we're updating the policy.
Dick?
This is something we've been discussing quite a bit because we have some peculiarities about our situation. We have created a kind of a subsidiary organization to look after Symphony Woods. And we have members, crossover members, who serve on the board and serve on Inner Arbor Trust. And going by the new language, these individuals who represent CA at CA meetings would not be able to discuss Symphony Woods or Inner Arbor or vote. And these crossover members are the two people who know the most about Symphony Woods, Inner Arbor Trust, what they're up to, what they're doing, and this is how we protect CA's interests. And, you know, we keep talking about, you know, what the standards are. I don't think there are any standards on this, because I don't think there are very many situations where you have a corporation delegating part of their responsibility to another corporation. The other thing I don't like in the new one is it keeps talking about a potential conflict of interest. Either you have a conflict of interest or you don't have a conflict of interest. Mm-hmm. And if there's some foggy idea that, gee, maybe you took a course in college on this and that gave you some ideas or anything like that, or you happen to know somebody who's the neighbor of a guy who's doing something, this can get stretched awfully thin. I think a situation is when you go in and you have made a contract, you're getting money from some deal, you're cutting special deals that benefit you, yourself. That's not a conflict, or that would be a conflict. But in a situation like this where you are representing CA in another organization and you come to a CA meeting and you are there loyal to CA, you have a duty to CA, you represent CA, that's not a conflict of interest. So that's why I was very unhappy with this language. It also suggests that when we, as members of our village or representatives of our village, try to get a playground built or try to get a swimming pool hours changed or anything that benefits our village, that we have a conflict. No, we don't have a conflict. We are representing our constituents, the people who voted for us. That's not a conflict of interest. And everybody knows what village we're from.
Okay, Dick.
So that's why I want to keep the
Keith?
original.
Just as a member of IAT, I read the new ethics policy, and I'm comfortable with the language that's in there based upon the conversation that we had prior. So I just wanted to state that. And I also believe that what we're talking about is not necessarily what's in the ethics policy. We're really talking about education around what this looks like, and then we all have to apply our own view of what we're learning about ethics. And at that point, it can be challenged by anyone, but that's all we can do. Otherwise, we're going to continue to debate about the nuance of the language. So my position would be that we would move forward with the ethics policy as it was written before the amendment.
Alan?
Yeah. I would just add to what Dick said that the people who should, and I said this before, the people who should have a concern about this is the board of Inner Arbor Corporation. That's where any conflict would be. The members that we have represent CA to the Inner Arbor board. Their purpose is to bring back information and be knowledgeable, and to stifle them here at this board would make no sense at all. I will say that we had a resident who suggested that we should get a divorce from IA. I sort of feel the reverse. I think we should eat our young Like have IA come back within CA and have it all be one organization. The other thing I would say that goes along with this is it's really clear that we have conflicts of interest that we allow. I asked at the last meeting of an attorney, what about voting on the rate increases? And how is that? We get to vote on raising a rate which raises our rates or not raise. That's so obviously a direct conflict of interest. And the response was, I don't have an answer for you. We just do that. That's the way it's done. So it's clear that there are things that we can't draw up hugely bright lines. So I agree with you in a certain sense. It's how we work it out anyway, how we play it out, how we act it out. That's going to be important. But the language is more draconian than my understanding from talking to at least one lawyer, that the law requires, it's more draconian than what the law requires. The law does not require that kind of recusal.
Bill?
I think that this sets up a clear conflict. It just says we're not going to take action on this conflict. And I don't think that bodes well for this corporation going forward. It's if you're going to give $200,000 to a corporation that you sit on and say, well, let's go to the CA board, I think I could get some scratch, and then say, yeah, we got some money, let's go find a way to spend it. That's a conflict.
That never happened.
And so that needs to be resolved. This doesn't resolve that.
Andy?
Oh, Jenny was up first before me.
No, go ahead. I'll go
Andy,
after him.
Yeah, IAT is actually an interesting one because if you look at IAT's documents, they basically state right up that each CA director on their board shall be deemed to have a conflict of interest with respect to any agreement or transaction between IAT and CA. So IAT recognizes that there is an inherent I mean, they even just say, look, it is a conflict of interest. We know that. And to me, it's like, well, they know it, and we know it too. I mean, it is a conflict of interest when you serve on two boards. You can kind of, try to make, transactions and agreements. The second thing I want to point out is just because you have a conflict of interest, the way the policy works is that simply brings it to the board's attention for making a decision as to whether or not you can participate. And there have been cases, I think, where, the policy shows, says what you do. So it isn't like you have a conflict of interest and immediately, you're banned and can't say anything. I mean, what the conflict of interest does, even according to the policy, it says now the board has to make a decision. In essence, do you still allow? I mean,
where is that text in?
That's what that's.
Just give me a section and I'll read it.
I'm sorry. When a board member has disclosed the
what's the text number?
It's on page 7.
5.00.
Yeah, it's under 5. Say 1, 2, 3, 4, 5, 6, 7. 7th paragraph.
Yeah, it's at the end of section 5.00.
Thank you.
Yeah, it tells you what to do, and it says the board makes a determination, and that's really what just has to be done. And I think this is where we're getting hung up. We're trying to say it's not a conflict of interest, and it's like, man, even IAT recognizes a conflict of interest. But there is a process. What that does is start a process for determining then. The board could sit here and say, yeah, we understand you have a conflict, but it really doesn't matter, doesn't impact. I mean, whatever the board decides. That's what I wanted to say.
Ginny?
Could I ask a question on Andy's point?
Okay, you can ask a question on Andy's quick.
What this says is when a board member has disclosed a conflict of interest, and I'm going to do it ... they will refrain from participating. It doesn't say the board will decide or the board will take it up. I'm not clear where you get your assertion of what it says.
Unless the board agrees the best interest of CA.
You're going to answer that?
I'm sorry, I read it as when you get the conflict of interest.
When a board
I mean,
member has disclosed
when
a
you
conflict
are
of
acknowledged as a conflict of interest and you want to participate, then it goes to the board for a decision.
Where does it say that? Because it says when a board member has disclosed,
right,
the board member will refrain from participating.
Right. But then it goes down and says.
Not the point of decision, but the board makes a decision. That's what I'm reading.
So this is where I'll ask counsel, what's the correct interpretation of that code?
Any provision in here can be waived anytime. So is that draconian? Yes. I mean, I'm hearing a lot of things that I'd really like to comment on. Conflicts of interest happen every day. They're not against the law. It's how you deal with them. To say that there's not a conflict between CA and IAT where there's an interlocking directors is just incorrect. It's a circumstance. If there's a circumstance where you sit on this board and you have another loyalty that competes with your loyalty to this board, under any circumstances. So if it's a transaction where the interests of this entity could be damaged to serve the interests of another entity that you also serve, you should recuse yourself. Now, the law has ways to cure that. Ethics is something different. Ethics is what you all decide you want to do. But the law says you have a duty as a director to act with loyalty to this organization. And you can't wear the hat of loyalty to any other organization when you're in this room acting on behalf of this organization without disclosing it. Right. That's if the entities have different interests, a director of a corporation cannot be a representative director.
So can I make 2 points and I'll get to Josh and then Jenny. One, people in IIT have certainly disclosed that they're on IIT. In fact, the board chair announces that they're on IIT at the very beginning.
They are.
Everyone knows who they are.
To say that never happens is incorrect as well. That does happen many times with related, particularly in the not-for-profit world, related entities. And there are really challenging situations where you have to stop as a director and you have to say, okay, I'm here as a director of this entity. Is the interest of this entity also in play here? If I'm a director of that entity as well, then I have to stop and I have to go, I can't participate. I can't carry the loyalty of both organizations at the same time.
Hey, Josh.
All right, so let's reverse this a little bit. Let's say you're one of these our vote this year with regard to our budget was that we were going to vote to give IAT a grant pending an audit of their books. So what happens when one of our crossover board members who sits as essentially as our eyes and ears on their board finds out that they hadn't audited their books or that they were having difficulty finding an auditor, because apparently that's a hard thing to find these days. Is that crossover board member not allowed to come back to us and tell us, oh, hey, by the way, they haven't done an audit yet? Or is that a conflict? Because because it says here you cannot participate in deliberations. So if I learn something that might potentially be averse to CA, do I have to hide that from CA now?
You've got a duty of confidentiality to someone else. You can't sit on another board as a representative of anyone. Someone's entitled to designate a board, happens all the time. A director happens all the time. But when that director walks into the room, the law says, Section 2405.1 of the General Corporation Law, you have to act with a duty of care with absolute loyalty to that entity and in good faith. Boom, done.
But I can't, and if I hear something there or I hear something here, I can't unknow what I've heard. I think that's where.
And you have to make a decision when to step out. It's not against the law to have a conflict. It's how you deal with it. Because they come up every day, all the time. Mm-hmm. All the time.
Jenny?
I'd just like some clarification. I thought IAT had another document that did not deal with that issue, did not say that somebody from CA has a conflict. I had heard that at our meetings.
I wouldn't know the answer to that.
I know, I'm looking more at Lynn.
Yeah.
I thought this was the first document that came out, but I thought after that, there's another one that does not deal, say
I
that.
believe they got a couple of, policies.
Since I'm on
But
the
Dick?
IAT board, I can say no, that this has been discussed at IAT meetings, and they say, yes, as CA representatives, there are things that we should probably not be voting on. And I will also say that when we walk into this room, we represent, and our loyalty is to CA. I think we've all agreed to that. Now, we may be on other boards, we may have other interests, but when we walk in here, we are loyal to CA. There is no getting around that. I'd like to call the question. I think we've
Lynn has not spoken yet, so I'll give Lynn.
I was just going on in that same paragraph that we're dealing with. And it just simply says, in the context of a contract or business transaction with respect to which a conflict of interest of a board member is known, the board will not approve the contract or transaction unless the board determines that 1, entering into the transaction or a contract is in the best interest of CA, 2, the transaction or contract is fair and reasonable to CA, and 3, the transaction or contract does not and should not result in the appearance of impropriety. That seems to allow participation as long as the board allows it.
So
that is a statement of how the law permits you to cure certain conflicts. If
But
there's
it's
a,
the majority
and this goes back
directors do
more,
Continue.
sorry, was I?
No, go ahead. Go ahead.
Sorry. If a director has a financial conflict of interest in a contract, that contract is void or voidable under the law unless the conflict is disclosed and a majority of the directors, without the participation of the conflicted director, takes those 3 actions, approves the contract in that manner. So somewhere, and this has been in your code for some time, but that's really a statement of corporate statute.
Okay. So I would like to call the question on this. On the question of Amendment 1 to basically replace the conflict of interest definition in the proposed code with our current policy. Alan, how do you vote?
Yes.
Andy?
No.
Bill?
No.
Brian?
Yes.
Dick?
Yes.
Ginny?
Yes.
Josh?
Yes.
Keith?
No.
Yes.
Lynn? I vote yes. The motion passes 7-3. Can I get another 15 minutes of discussion? We've got a couple more amendments on this.
Okay, go for it.
Seeing no objection, we'll put 15 minutes. The second amendment, let's see if I got this right.
Mr. Chairman, I'm sorry. Did you just dispense with amendment number 1?
Yes. So we voted to approve amendment number 1.
Oh, you voted to approve amendment?
Yes. The motion to approve amendment number 1 carried 7-3.
With the view to account for the special relationship of board members with IA.
I think it's a dead issue.
No.
Okay.
Basically, we're using the current policy.
Yeah.
But the current policy does not recognize IAT and CA as a conflict.
So, okay, but I think it's important to be clear that you could put in your policy that it won't rain on Thursday nights in Columbia, and it might not.
This discussion is over.
Yeah, we're moving on to amendment 2.
Can I make a quick recommendation before you continue? So you just passed an amendment
Yes.
that goes against the guidance that has been provided by a number of different professionals, independently, qualified professionals. My suggestion, which is a variation of what Dennis brought up, is that as you continue down, any other amendments that are significant deviations from what has been proposed by Miles and Stockbridge be deferred for consideration by the next board.
Duly noted. The chair will also note that the amendment that passed basically uses our current text, which is pretty similar to what Dennis proposed, tabling the whole thing and just using all of our current text. So the original motion to table, which actually would have supported if it actually called the question, because I think it would have saved us a lot of time, would have preserved our entire existing policy.
Which is what we just passed.
And right now, Amendment 1 takes some of our existing policy and plugs it back into our current policy.
Mr. Chairman, to be clear, what the president had suggested was to table this entire discussion so that another board could look at it in a robust manner and allow for vetting by legal experts. What you have done with your affirmative vote on this amendment is to endorse the existing policy and to, unless it is undone by a future board, continue with what has been described as not a good idea.
We all endorsed the existing policy. We all signed it.
Point of order? Or whatever.
A point of order, yeah.
What's the point of order?
That we need to move on.
Yes, that's where I was going.
Okay.
So Amendment 2, the motion, the chair moves to replace the last three sentences of paragraph 1, section 6.04 with, and this is actually from our current policy, CA personnel and board members receiving a request for such gift must report it to the principal ethics officer. Any CA team member that is offered tips should consult with the team leader or director of human resources. Anyone with questions about whether accepting, offering, or providing gifts or entertainment is prohibited in any situation should contact an immediate supervisor, team leader, director of human resources, or the PEO. This basically means any reporting basically goes to the PEO. So the chair moves, Ginny seconds. Any discussion on Amendment 2? Dick.
I notice we have the term PEO that shows up in here, and we also...
The Principal Ethics Officer.
No, I'm aware of what it is. I'm just saying, have we established that we have a PEO, or is that...
Who's the...
We also, in here, we talk about an ethics committee, which also does not exist. So I'm just wondering if we need to clarify what this...
Who's the current PEO in absence of the general counsel?
It depends on the circumstance. That we've got co-administrators of the hotline, which is myself and assistant general counsel, and then we have outside counsel as needed. But I just wanted to mention that for the vote that the board took in January of this year, they acknowledged that there is a PEO to handle ethics matters, except for at the senior level, the senior management and the board, and that would be handled by an ethics panel, and that's what's incorporated into the Miles and Stockbridge version that is up for a vote. So to remove that would go against, if you're replacing language and just saying PEO, you're going against what the board voted on in January.
Okay.
And does that then need a vote to unwind that first?
Any further questions? Alan?
I'm not clear on that, because it says that the board member receiving the request for such a gift must, I'm not sure what the request for a gift is, but...
This is just a reporting requirement.
Yeah, it's just about reporting. It doesn't say who's going to then handle it.
And
okay.
Yeah, so this is just reporting. So I think it makes sense for all the reporting to go to one person. Otherwise, it could get confusing. You report here, you report there. As long as if we get all the reporting going to one central place, I think that makes things a lot easier to deal with.
So call the question.
Any further comments or questions? In that case, I'll call the question. Lynn, on the amendment in 2?
Before we vote, what is it? I'm not clear with this request for a gift.
Yes. So if someone basically requests to give you a gift or offers to give you a gift.
Offers, okay.
Yeah.
Offer to me than a request. I hear that that's the language we're using. Thank you.
The language that you're replacing mentions the ethics committee in 3 different places. So I just want to make sure everybody's clear that it was there for a reason to incorporate the decision made by the board.
But the PO could certainly forward it on.
Right, that's a separate.
Can I call the question, Lynn? On the amendment. Keith?
No.
Josh?
Yes.
Ginny?
Yes.
Dick?
Yep.
Brian?
Yes.
Bill?
No.
Andy?
No.
Alan?
Yes.
Chair votes yes. The amendment passes 7-3. Next, we have a proposed amendment by Dick Bolton in section 2.0, paragraph 4, retain the verbiage sets the president CEO compensation, which was removed from the red line. Can I get a second on the motion moved by Dick?
Oh, I believe.
The chair will second it. Any discussion on the amendment? Dick, do you want to introduce it?
Yeah, it had a list of what our duties were, and for some reason that was taken out, but that is clearly our job. We do set the compensation. I couldn't understand why it was taken out.
Any further discussion on this? Any further discussion on the line? Rationale for taking it out? There being none, I'll call the question. On the motion to re-add sets the president CEO compensation, moved by Dick, seconded by the chair. Alan, how do you vote?
I'm sorry, this is in the ethics policy?
No, the introduction gives a list
In
of
section
duties
2.0.
of the board. It was originally a code of conduct, and there's several sections in there that have to do with what the board can and cannot do.
Okay.
And among the list, of setting policies and strategy and yada, 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 it used to say hires the CEO and also sets compensation. And that somehow disappeared in one of these reiterations, and I'm just saying, I don't know why, and suggest to go back in.
Maybe it was an oversight.
I think it was just an oversight.
Okay.
Any further discussion? I'll call the question. Alan, on the, Andy?
I'll abstain.
It's a new column. Bill?
No.
Brian?
Yes.
Ginny?
Yes.
Josh?
I'm going to go no. I don't understand this one at all.
Lynn?
Oh, yes.
Keith?
No.
Dick?
Yes.
I vote yes. The motion passes 6-3-1. Got Amendment 4 in Section 3.14. Dick moves to strike the words for compensation in excess of $2,500. The chair will second. Could you explain this amendment, Dick?
Yeah, this, I'd like to know what people think on this. It says that after someone leaves the board, such as me, they could come back to CA and work for CA, during the coming year for $2,500 or less. And I think this is an ethical question. I don't think that we should get paid, within a year of leaving the board for anything we do. If we want to volunteer something, that's fine, but I would not want to see a situation where some kind of a deal was cut and then the board member gets $2,500 for doing some kind of scope work. So I just think that the amount should come out. You just should not be paid for a year.
Alan?
Yeah, what I'm confused about on this one is the clause for compensation in excess of $2,500 refers to that coming from another party, not coming from CA.
There are two of them in there. One is you can't work.
There's only that one clause. And then the next clause talks about being employed by CA.
Yeah.
That doesn't have an amount.
Oh, I guess I already took it out. Okay.
So
then never mind.
Okay, do you withdraw the amendment?
I'll withdraw the amendment.
Amendment is withdrawn.
That's a quickie.
Next, we have a amendment by Dick. In section 4.0, strike the last two sentences regarding board members speaking to the public. The chair will second. Dick, could you explain this?
Yeah, I go back to my village board and tell them what the board has done. And sometimes they'll say, that was stupid. Well, why did you vote for it? Or why didn't you vote for it? Or whatever. And I like to explain why I took the position I did. And when I was up for re-election, again, people would say, why did you take that position when the board approved for something else? And I want to say, well, look, I feel this way about that, and if you reelect me, I'm going to take the same position. I don't think we should, I think, I just don't understand why all of a sudden we have to go through the PR lady in order to communicate with our own constituents.
Alan?
I'm not sure which version you're looking at. The last two sentences of that section don't include what you're talking about.
I don't have
The
that.
last two sentences are, any inquiries from the public should be directed to the president or the board chair, and in addition, the board member may speak on issues in his or her capacity as a private individual. But the sentence is third from the end that says, board members shall not speak to the public.
That's the one this thing has gone through so many changes, I must have been looking at an earlier version. But I don't like the idea
They
that,
change, maybe just remove that one sentence.
yeah, move that last.
Could you repeat the sentence, please?
Board members shall not speak to the public regarding matters considered by the board except to reiterate board decisions and other factual matters in public record.
Board members shall not speak to the public,
Regarding matters.
was the end of it.
Where do you see this? I don't see this.
The last paragraph of section
Here,
4.
It's under the civility policy 4.4.
Okay, so
third
I
line.
don't see I'm looking, I don't see a shall not anywhere here.
Look in the middle.
Sh-
It's the
a third-
sentence, board members shall not speak to the public.
Page 6.
Yeah, so
Paragraph that starts with the board must speak through unified message.
what paragraph number is that?
It's not numbered, it's the last paragraph of section.
Okay. So we've got a friendly amendment to strike from the last paragraph of section 4, the sentence that begins with board members shall not speak to the public regarding et cetera, that sentence. Keith, do you have a comment?
Yeah, the piece that, we're reading pieces of it, but it says, except to reiterate board decisions and other factual matters of public record. Our meetings are in public record, so there's no reason why you couldn't go and speak about anything that you've discussed, your vote, anything that is of public record. So I don't see why we would need to take this out, nor do I see why we wouldn't be able to relay that information to our village boards.
So the question is, does this sentence do anything? Bill?
This is fairly common language for most boards, most organizations. I don't, you have to walk a line here. And, I'll tell you what, up until tonight, if the Baltimore Sun called me and said, what do you think about this? I would say you should talk to the board chair about this or to the CA president. That's typically what I would do. What you're saying is that I should just open up everything that I was thinking about and just stir and muddy the waters as much as I feel appropriate. That seems to be counter to board continuity and messaging. But I know that people get wrapped around axles at times, but this is pretty standard stuff. It should be able to talk to the folks in your village and say, yes, the board did vote on this, this is what it was, and this is the discussion that transpired. This is the factual basis of it. To remove this is to just say, hey, it's open season, and I don't know if that's beneficial to this corporation.
Josh?
I was going to vote against this one until I heard that, because we're not Coke or Pepsi. We're not giving away the secret to Coca-Cola's recipe. We should have the right to speak as individuals about how we feel about matters pertaining to this board, and this line seems to call, and what you just said seems to call that into question.
Alan?
I get your point, Keith, that most, I don't know about most, many things would simply be reiterations of things that have already been said in the public record. But there's lots of things I know that I don't either have a chance to or don't say, or they come to me later, or they just weren't part of what I said in the public, but are still part of why I might support or oppose or have questions about something. So if I'm limited to just reiterating what happened in the public meeting, to me that's too limited. I agree we are not Coke or Pepsi. We are not the kind of thing that we can't. For me, the line is we can't do things that actively undermine sabotage a board decision, but speaking out against them as representatives of our constituency, that's why we get elected.
I got a point of information that I'll direct to council. So we have the text board members. So when it says board members shall not, does that mean that we shall not do this stating that we're a board member? And does that allow us to do that as an individual? So if we're saying, these are my thoughts as an individual, is that different from saying, okay, these are my thoughts as a board member? So
Which is down.
Section 610 addresses you as an individual. This is not a typical municipality. We heard a lot about the history of Jim Rouse and whatever wisdom. He chose a corporate entity for this. A board of directors of a corporation is intended to act collectively. And your actions you should all take away from here as the actions of you as the board. True, you have a number of meetings and take actions in a public setting, and your vote is known potentially, but you're not intended to be here as a representative. You're not the General Assembly. You are a corporate entity, which is why a lot of things that you're undoing were drafted the way they are, and it doesn't really change the corporate law. You've got a duty of loyalty to this organization. The board should act collectively and take away the decisions and speak with one voice outside this room.
So I guess that still doesn't quite answer my question. So my question is, say a board member was to say X. This would preclude them from saying...
As a private individual, you have the right to speak on issues.
Okay.
That's in 610.
So
As a board member, it's either speak the line of the full board or refer the conversation to a board spokesperson.
We are ex officio members of our village boards. Ex officio because of our, well, I'm not sure, it's not because of our position on this board, it's because we were.
It's because it's because of our position on the Columbia Council.
Our position on the Columbia Council, but that's how we're voted by the so okay, that takes care of that.
Dick?
As I said, I think that, yes, we say the board voted this way or the board voted that way, but we can also say, I have a problem with that. And if it comes up in the future, this is my position. Maybe we're speaking as an individual, but probably we're speaking as a board member. And I have to say, some of the comments that I have heard from board members who have been pretty hostile to decisions that this board has made. and pretty vociferous about it in public forums, and including letters to publications and a lot of other things. And I respect that right to speak one's mind.
As a private individual.
Yes, but if I'm in my village board meeting, I'm there as a representative of the CA board.
No, you're not.
No, you're not. You're there as you're there as a village board member.
Yeah.
Well,
Ex officio.
We cleared that up. It's not.
You're there as a village. You're a village board member when you sit on the village board, and you need to be a village board member. And
I think that varies by village, but in any case, yes, I'll accept that. But I am concerned about being muzzled and not being able to say, look, the board agreed to this. I don't particularly go along with it. Here are my reasons, but this was a board decision. And I'm just worried about people who do criticize something that the board does, as we have had several examples, that they're going to be muzzled. I think that if you want to spout off about the way the board handled something, you have every right to do that.
Jenny, do you have a question?
Yeah, I'm just trying to figure out where we are here. So, Dick, what are you now suggesting is that third sentence be removed? Page 6,
It's
third sentence down, board members shall not speak to the public.
Yeah, that's the one.
And end at record.
Yes.
I don't have that in front of me.
Yeah, strike this sentence.
That's what
Board
you're
members shall
saying.
not. Yeah.
Okay.
I will.
I just don't understand what the issue is, though. It seems like it's okay, it's covering it.
The other.
Especially the last sentence, board members may speak on issues, which is the same as 610.
Keith? As I understand it also, if someone wants to speak, they just need to make the statement that they're not speaking on behalf of the board. Now, that's a sneaky way to decide to go and lambaste your board members, but if that's what you want to do, that's what you want to do.
I mean, I want to believe that. I want to think that that's true. But again, this puts somebody with a minority viewpoint, basically makes that person subservient to the majority. And I'm concerned about that.
But it also says that you have the opportunity in this forum to I forget the language, but to appropriately present your argument. So it's documented for everyone to see. So that's public record. So if you want to go through and blow something up,
So
minority.
I hope you're right.
Okay.
I mean,
So let me try to frame this in a practical example. So as a member of as the Columbia Council representative from River Hill, I actually write a column in our newsletter every month, which discusses board activities, and I do a little bit of editorializing, as you might guess. So does this statement preclude me from doing that? And yes, at the end of the statement, there is disclosure that says that the text above represents my viewpoint and not necessarily the viewpoint of the village or the board of directors of CA. So does that prevent me from continuing to write my column every month?
I'd have to look at the words that you end it with, but as long as it's clear you're speaking as an individual, not as a board member, then you're free to speak. But your duty of loyalty to the corporation doesn't disappear when you walk out of this room.
Understood.
You have to, whenever you're acting as a director of this corporation, you have a duty to the corporation.
Ellen.
Two things. One is the corporation has a mission and a purpose. And if I would just speak for myself, if I believe that this body has made a decision that I believe is contrary to the interests of the mission, then to me it is fulfilling my duty of loyalty to speak out against it.
In this room?
Anywhere.
Not once a decision is made.
I'm saying what I believe. I'm not saying what you think.
Which isn't public record, right?
That's the difference between ethics and duties.
My duty is loyalty to the corporation. The corporation has a purpose to serve the.
That's not the purpose, that's the mission.
That's the mission. But
anyway, has a mission. So serving the, even more important, serve the mission.
But you're saying in public record, though?
Yeah.
Like you've made your.
Not certainly not sharing things that are private or confidential.
Yeah.
But so I'd like to sort of reverse or take the converse of your question. I'd like somebody to speak then, given all this, what does this sentence do for us?
what's the
purpose of keeping the sentence in here?
That's a question for council.
No, it's a question for anybody who wants to answer.
What's the purpose?
I'd like to. What will this sentence help us?
This document is to set forth your view of ethical behavior by you as directors.
This particular sentence.
That's part of it.
But what behavior?
I don't think that's new. I think you've approved this before and lived by it and signed it. I think that's always been there.
It was this whole thing about except to iterate board decisions and other factual matters of public record was added. So I'd love to hear what might be done that this would prohibit.
Anyway, Dick?
I would just say that when somebody at my village meeting,
I'm sorry.
Someone at my village meeting asked, why did I do that? I'm not going to say, well, you can see the video on the web where I've laid out my arguments. That's not what I'm going to do. I'm going to say, this is what I believe. I think the board made a mistake here. I'm allowed to do that.
Yes, you are.
I do not want to be in a position where I cannot say, hey, look, I think we ought to do something different.
You absolutely can by what's written here. That's the piece that's frustrating to me about this discussion is it specifically says that you are going to lay out your argument. And sorry, I didn't ask for permission. You're going to lay out your argument in a public forum. You're going to present all sides to the point that you, and forgive me, I can't remember the language, but that it's been presented appropriately. So hopefully you're doing that here, and you're not withholding information as we're having the discussion. And then once you've done that, it's in public record, and you can go.
Wait.
But you can go and say that.
One person at a time.
Not everybody is watching these videos.
But you can speak what's in public record. That's what this says.
So I think the question is, if you vote in the minority on a question, say you're in the minority on a 7-3 vote, and you want to defend your vote, are you allowed to?
Yes, that's what this says. It's in public record.
So
And why is this line in here that we can't speak?
I don't know, just to prove it, so we can move on to the next one, because it doesn't matter then, right?
So I'd like to, I'll call the question on this. On the amendment, striking the sentence from 4.0, last paragraph, board members shall not, ... Alan, how do you vote?
Yes.
Andy?
No.
Brian?
Yes.
Ginny?
Yes.
Dick?
No.
Bill?
No.
Josh?
Yes.
Keith?
No.
Lynn?
No.
Chair votes yes. The motion passes 6-4. That brings us to the main motion. So.
Have your hand up? Oh, yeah.
Yeah, I mean, as we were talking about all this, and it dawned on me that the next sentence following that says, any inquiries from the public should be directed to the president or the board chair.
It's still in there.
Given all the discussion we've had, but it brought to mind that I get questions like, where's the nearest tot? I mean, where's the nearest tot lot? How do I get to the CA web? I get a lot of inquiries from people, some of which I just answer myself. Others I send to Dan, or no, I don't send it. Sometimes I don't send it to the president. I'll send it to open space. I'll say, the bridge is out or something. I got a report that somebody knocked down your sign.
I'd say if it's a obviously factual thing, like Lake Kit is over here, it's fine.
Yeah, okay.
If the Washington Post comes knocking on your door, you might want to refer that to our director of publications and media.
Right, that's a little different, but it's just inquiries.
I think inquiry means a press inquiry.
Well, how about if we make it explicit and take out the words "from the public or," so it changes it to any inquiries from the media.
Does the media include blogs?
Blogs.
So right now, I don't have a motion on. Right now, is someone going to make another amendment that's not on here?
I'll move to strike the words.
Strike the words what?
From the public or, after the word any inquiries.
Can we at least put the whole policy on the open? Because we don't have anything to motion and discuss. So can we just put the policy up, and then you can make your amendment to the policy?
So there's another amendment from Alan. Is there a second on this amendment? Second by Dick, to strike the words "from the public" or those 4 words in the question of any inquiries from the public, any inquiries, strike "from the public" or from the media should be directed to the present CEO or the board chair, or if from the media, the senior manager of media and relations.
It's a little redundant.
And that's kind of redundant here. I'm not sure this is the right wordsmithing.
What words would you suggest?
I would just leave it as is. You're allowed to talk to your neighbors. You're allowed to table.
Okay, I'll withdraw.
Second. Motion is withdrawn.
I'll withdraw.
The motion is withdrawn. That brings us to the main.
I would like to also just suggest, and this goes through its final wordsmithing, that I thought I put this in a request, that the preferred verbiage these days is not his or her, but it's their.
I'll take that as a edit. So I don't believe any motions needed. It's just a edit.
Good point.
So that brings us to the main motion that was moved by the chair, seconded by Dick, on moving the ethics code as written. Any final discussion on the, as amended? As amended. Moving the ethics code as amended. Any further discussion on the main motion? Seeing no discussion, I will call the question. Lynn, how do you vote on the new ethics code?
Yes.
Keith?
Yes.
Josh?
Yes.
Jenny?
Yes.
Dick?
Yes.
Brian?
Yes.
Bill?
No.
Andy?
No.
Alan?
Yes.
Chair votes yes. The ethics code passes 8-2. You have a new ethics code. Next item on the agenda is 7B, the enforcement piece. The chair moves to establish the revised version of the policy for reporting violations of the Code of Ethics and Business Conduct, the conflict of interest policy, and the special requirements for members of the board of directors. Do I have a second on the revision?
Yes,
Jenny
second.
seconds it. This actually has several amendments. We have an amendment by, so the main reason, so before I go into it, the amendments, the main reason for this is to make sure that when an ethics complaint comes in and it comes to the chair, that it's not just the chair that has the sole responsibility to decide whether or not it needs to be investigated, that decision goes to a full board vote. So that's the main impetus for it. So it's, the chair is not the sole arbitrator. We do have several amendments. The first amendment is from Andy, seconded by the chair, to add the following sentence to the end of section 1, paragraph 1. CA directors may not submit anonymous ethics complaints. So that would make it so that any CA director would no longer be allowed to submit complaints anonymously. You can still submit complaints, but you have to attach your name to it. Any discussion on the anonymity clause?
Why?
Why?
I'd be delighted to answer.
Dick got his hand up first.
We give you a hypothetical question to answer.
Please be hypothetical, Dick.
I'm going to be hypothetical.
Very hypothetical.
So should a board member make an anonymous complaint, that board member would not be allowed to vote. Ought not be allowed to vote. But if the complaint is anonymous, how would you know? And at the level of complaints that would be important to the board, I don't think there's any reason I can see why at some levels we have like a sexual harassment problem or something, that I could see why somebody would want to make that anonymous. But when you get to the board level, we should be able to stand up and face our peers and make that claim known. And we can usually figure out who that person is anyway, hypothetically.
Hypothetically. Any further?
Yeah,
Jenny?
I think if you're trying to establish hopefully a team approach and a working relationship, and it really undercuts it when you have, and we've had this, a board member anonymously file a complaint against another board member. If you don't have the courage and guts to just say what you're thinking and do it, I think that's pathetic, and I don't think we should the board should allow for that.
Keith?
Yeah, those statements kind of turned my stomach almost, especially because you talked about sexual harassment and things like that. So to say in this day and age that to not have courage to speak about sexual harassment or other issues seems really, really inappropriate, given that we're trying to get people to bring things to the table, and when they bring things to the table, they're really not handled in a responsible, respectful way. So it seems like if we're dealing with a sexual harassment situation or something along those lines, I would want folks to be able to do that anonymously. And the cool thing about this that we've already voted on that we can put in place is we wouldn't need all of this if we had an ethics committee. So, well, We have an we
have.
Please stick
It's
to
not
the.
off. It's not off. It's
on track.
we've approved an ethics committee that we have not decided to move forward with. Someone has stopped it along the way, so that.
No.
Wait.
Let Keith finish his statement.
Eric,
No, I finished.
okay, so I'd like to remind people to stick to the topic of the motion on the anonymity. So does this refer to the motion on anonymous what?
I think this refers to board members only making accusations.
Yeah.
If it's a staff member who thinks that a board member has been out of hand, that certainly could be an anonymous complaint. But if it's something that's happening among 10 members of the board here, and again, I don't want to talk about cases that have come up, but we have had problems where anonymous complaints have been made.
Josh?
I'll just say this, and I appreciate that scenario, and that's a frightening scenario, and it shouldn't happen. Here's my thing. If a director files a complaint against another director, whether you're anonymous or not, there should be 8 votes. There should be 8 votes, because the complaining director and the complainee should not be voted. So there should be 8. And the reason this is being considered is because we've had situations where directors filed complaints against other directors, and there were 9 votes. And that should never happen.
So if it's done anonymously, how would you know?
Yeah.
If it's a director or someone else?
Which is why we're considering getting rid of this.
Bill?
I think that when we're dealing with ethics complaints, we should be lowering the bar and allowing people, as they are comfortable, to make those complaints if they believe they are real and valid. Ascribing terms like pathetic to future board members is not productive. I think that we should be able to allow people, if they feel that they are not comfortable to be visible in making their complaint, to do it in an anonymous manner if they believe an ethics violation occurs. That is what is at the heart of this. We should be making sure that it is easy as possible, if somebody believes that an unethical behavior is happening, for that complaint to go forward. To say that they are pathetic is not good. We need to come back to where
what does
we
this
are.
have to do with anonymity?
If you can make a complaint anonymously, that is another hurdle that you don't have to jump over in order to make that potential ethics violation known.
So I'll go to Alan next. He hasn't got in on this.
What we have here, I believe, is as often happens in life, is where we have different values that can come into competition with each other. And we have to make a decision around it. I agree. I want the bar to be, I want the ability to make a complaint to be as accessible and available as possible. I think we're making a mistake when we go down the road of we're not talking sexual harassment. Sexual harassment is against the law. We're talking about a violation of this ethics policy where I think that, or Dick thinks that I badmouthed a director in public. And as Josh has said, Dick ought not to be voting on that. And I guess nor should I. Or if I can't vote on it, Dick shouldn't vote on it. But if Dick can make that complaint anonymously, then he's allowed to vote on it, and that puts my interests at a disadvantage. So I think clearly, if we feel somebody broke the law, there are ways it goes beyond our ethics policy to make that complaint, and that ought to be that person who is alleging that kind of thing their privacy ought to be protected to the full extent of the law. But in this case, the only way we have really to make it fair in terms of both the discussion and the vote is to know who the complainer is and who the complainee is.
Josh.
Just in the interest of harmony, to folks who are against this amendment, would you support changing our policies and saying all 10 directors can vote?
I would.
Because to me, it's either 8 or 10. It's never 9. 8 or 10.
Jackie.
So if your hangup is the process of how this would happen, and you would find yourself in the unfortunate position where there is a board member that wants to file a complaint against another board member and does not feel comfortable doing that other than anonymously, again, we would hope that we wouldn't be in that situation, then clearly the board member that has been accused would not vote. You would have 9 people that can vote. They would all put their vote on a piece of paper, and the person who has made the anonymous complaint would indicate something, not their name, but just a check mark, whatever that would be, and whoever collects the votes takes whatever that vote was or that piece of paper and they disregard it.
But that still allows them to be part of the discussion. If the person who's being complained against ought to be recused from it, so should the person who's making the complaint.
We can deflect all we want and complicate it all we want, but there are ways to do it. I think you should talk more as opposed to procedurally, conceptually, as to what you feel that you should be mandating.
Ginny.
How do you know it was a board member that filed a complaint? Because if you have situations where a complaint is filed and the board member doesn't acknowledge that he or she filed the complaint, you could assume it's from somebody outside. Who would know? I assume maybe you'd know if you got it, or the general counsel would know, which I want to know why you'd know and the board wouldn't know, I guess. So we're back to what's the sense of it being anonymous? In other words, how can you stop that person from voting if the person isn't acknowledging that they actually filed the complaint?
I think Susan is.
Susan?
I just, perhaps I'm not understanding the spirit of the conversation, but just as a woman in a room where there are fewer women than men, and the situation of perhaps not feeling safe to bring forward a complaint, it seems to me that the complainant's safety would be a higher value than my own vote. And so it just troubles me that that's the nature of this conversation.
And I would agree with that if we were talking about sexual harassment.
And how would you know? How would you know that wouldn't come up?
Dick? To me, that's a violation of the law.
But how would it be reported, though?
The place where anonymity makes sense is where somebody's in a reporting relationship, where they're complaining about somebody higher up who can impact their job.
No, that's peer-to-peer as well.
I'm talking right
but you're wrong.
I am talking.
Dick's got the floor, please.
And that's a serious problem, and we all acknowledge that. We board members know each other, and in the course of this investigation or whatever, it would become known who that person is, I would assume, because otherwise the defendant would not be able to defend themselves. So we have had actual situations, and again, because this was all closed meeting stuff, I can't get into specifics. We have had situations where anonymous complaints have been filed, and the accuser, who, it's kind of hard to keep it a secret who the accuser is, and the accuser has participated in the discussions and in the voting. We have had a case like the one Josh suggested, where there's been, 9 votes where there should have been 8.
Anyway, I'd like to put a little perspective on this. So generally, you want to protect anonymity when you want to basically say you don't basically to prevent retaliation from someone higher up. But I mean, the board is as high as you can get in the organization. There's no retaliation. There's no authority higher up than the board to protect from. So, does that impact things? Andy, do you?
But I mean, this conversation really worries me between what you said and what Dick said, because it is not simply a case of a subordinate and a boss and a subordinate. You can be aware of an inappropriate situation going on with somebody else. It doesn't have to be you. And you have a responsibility to report that. Okay, so it's not just, the boss and the subordinate. That's what we've been getting away from. That has been the problem in the past. And our policies are pretty clear, even the one we just passed, says that if you are aware of an ethics problem, and ethics problems include anything related to, I'll say, the state or the local, that's how you make a complaint. That's how you make it. That's an ethics complaint. You've got to report that. And so I get really worried when I hear this conversation that, it's only certain situations that call for it. The other thing is maybe what we need to do is restrict this to simply against directors, particularly if
But that's what this was.
No, it isn't. Right now, it just says any.
No, this is. The director makes a complaint against another director.
No, it doesn't.
I thought that was the amendment.
It says very simply, CA directors may not submit anonymous complaints.
Right. Originally it said against other CA.
Do you want to just make it against other directors?
Yes, we should at least put that in.
Okay, well, I'll take a friendly amendment to say CA directors may not submit anonymous ethics complaints against other directors.
Okay.
I thought that's what it was, sorry.
Yeah, I thought it was too.
Well, now it is.
Call the question.
So I will call the question on the motion to add the following lines: CA directors may not submit anonymous ethics complaints against other directors. Andy, how do you vote?
Yeah.
Brian?
Yes.
Ginny?
Yes.
Keith?
No.
Lynn?
Yes.
Josh?
Yes.
Dick?
Yes.
Bill?
No.
Alan?
Yes.
Chair votes yes. The motion passes 8-2. The amendment passes 8-2. The next amendment is offered by Andy, Amendment 2. In Section 1A, after the second paragraph, add the following: for any complaints against the director with voting privileges, the CA board authorizes an automatic creation of a special board committee. And it goes into saying the special board committee is authorized to receive findings and recommendations, authorized to determine what, if any, corrective actions need to be taken, and is automatically disbanded after it determines what corrective actions to take. And any language in this policy that refers to action by the CA board is to be interpreted as just the special board committee. So I'm not quite sure I fully understand this, Andy. So if you could explain this text to me.
Sure.
Is this text right?
It goes after Section 1A. After the second paragraph in Section 1A.
So I propose this amendment.
By the way, do I have a second on this amendment before we get going?
Oh, that's true. Yeah, I will move it.
Okay. Andy moves, Keith seconds it, and please explain it to Andy, because I don't understand this one.
So for several meetings, we've had discussions about whether a board member can vote or not vote, what does our charter allow, all this type of stuff. And my thought is, look, you know what, there's a way around this, and that's you create a special committee that consists of all the directors who aren't involved, which a board can do, because a board can create committees, and you simply authorize them to make the decision. And that's all within what we do. I mean, it's just like we do the BOC. We authorize the BOC to approve agendas. We authorize the risk management to do certain things. So all I'm saying is, let's just put the language in that gets around all this problem and discussion we've been having on can you, cannot vote. We'll just say, look, the special committee, which consists of anybody who isn't involved in the complaint, either filed it or the subject, those who aren't involved get to form a special committee and get to handle the complaint.
Do we have a second?
Yeah, there's a second by Keith. Keith and Ginny's first in the queue. Ginny?
Yeah. So if a director filed a complaint against 6 directors, you would have a committee of 4, or depending on what you think about that director, 3 that would make this decision, right?
Yeah, special committee.
Or, which was one example, or the 4 that was filed against, you'd have a special committee of 6. I don't see it, I honestly don't. Too much danger there for somebody, no, I won't get into what I'm concerned as the negatives of this, but I don't think it's a good idea.
Alan?
I share the concern about the numbers, but I thought, a couple of other things. I thought that we had approved I thought we had approved a standing ethics committee. We haven't formed it yet, but I thought that we had approved that. This sounds like it's basically negating that idea and substituting with an ad hoc committee, and I'd love to hear the reasoning behind that. And the other piece that I'm concerned with is you made reference to things like the BOC. The BOC, yes, they create agendas, and then it's the board, the full board, though, that votes to approve the agenda at the night of the meeting. And the board at that time the whole board has an opportunity to make amendments. And I don't see that in the process that you're suggesting here. So I don't see the parallel that you're trying to draw.
Sure, let me address your first complaint, because originally I thought we had voted to approve an ethics committee and we had voted to charge an outside law firm to develop the charter and to revise the report, the violations, okay? And I thought that's what we were doing. And then suddenly, there was a proposal to make changes to the report of the violation, which I thought was supposed to be the purpose of the outside committee, okay? So then suddenly there's this, let's make amendments to how we report. And we're not going to bother with the outside firm because we're going to do it here at the board, which I thought is against our vote. And then this is only temporary until we get the ethics committee. I'm saying, all right, are we ever going to get this ethics committee or not? And if this is only temporary, then all my amendments are only temporary to apply until the new thing. So, it's either these amendments are temporary, all of them, because we're going to have a new policy written by the law firm, or this is going to be our policy. And I really don't know which one it is. And my thought is I'm putting my amendments in just in case to cover. And that's why. I'm thinking, and I really want some outside firm to write this policy and get us out of the middle of this. But Dick's willing to vote.
Dick?
I sympathize with you there. I think we have a problem of how we're going to get this thing going. And the first step was to get the ethics code agreed to so we could take that off the table and move on. The problem was that, as Eric has pointed out, that left us with no enforcement policy.
Well, we've got the current enforcement policy. Yeah, the current enforcement policy.
Yes, we would have taken away the first 3 sections of the 4-section code, but we would still, we would have the old enforcement policy. And that needed some immediate work. And when the new board comes in, there'll probably be, whatever they decide, whether it's the outside law firm or whatever, they're going to have to take another look at this enforcement policy. But in the meantime, we need something in place until that happens. And so that is what we're doing here, is we're trying to put together something that'll carry us over until the next board can really look at this in addition. The ethics code we've been talking about for 6 years. The enforcement piece has not had a whole lot of discussion.
Any further questions on this amendment? Josh?
Here's my thing about this amendment. Ideally, I like Andy's idea. I like the idea that, if there's a complaint, if there's an ethics complaint against a senior leader, it would go to a committee. I think that's a great idea. And I think where we have had problems, and the reason I think people want to talk about this enforcement is, I think there's a fear, and I don't know the answer to this question. I know that there have been residents who've come to speak out and say that there's supposedly a trove of ethics complaints that have gone unresolved, that there are some that were just quashed without any consideration. I don't know. I don't know the truth because I'm obviously not privy to any of that. I think that there is a fear, what has been communicated to me is a fear that there could be an ethics complaint against directors, possibly to influence the vote, and there would be a committee that would potentially have the power to just squat on that complaint and not take action until after a particular vote. And that was the concern that was raised in the Venable opinion that I'm told we can discuss publicly now, that essentially an ethics complaint can serve as a suspension of a director and prevent that director from voting. And if this committee is going to have the power to possibly prevent somebody from voting, I have a problem with that. I mean, we're here to vote. That's our job. And if there's a reason why we shouldn't vote, by all means, let's discuss. But I think we want to make sure that there's a process that preserves the prerogative of the ability of a director to vote when and wherever possible.
Yeah.
Call the question.
Can I call the question?
Call the
You're not
question.
suggesting you vote when it's an accusation against you.
Now, to be...
You said 8, right?
I said 8 or 10.
So 8, oh.
Now, we had a problem, and that's interesting, because when Miles and Stockbridge was here last meeting, they suggested, at least, and we'd have to check the replay, but it seemed like there was a suggestion that there isn't really a prohibition against you voting on a complaint against yourself as a director. That was the suggestion. We haven't done that. I have no problem with that.
That would be unwise.
To me, like I said, 8 or 10. But I guess the concern I have right now is an ethics complaint being used to essentially suspend a board member and a committee that could squat on that complaint for an indefinite period of time.
Okay,
All right,
call the question.
I'll call the question. On the amendment 2, how do you vote, Alan?
I'd like to vote later. I'm going to pass for the moment.
Okay. Andy, how do you vote?
Yes.
Bill, how do you vote?
Yes.
Brian, how do you vote?
Yes.
Dick?
Yes.
Ginny?
No.
Josh? Want to pass?
I'll pass for now. Like I said, I just want to know what the powers of this committee will be.
Yeah.
Keith?
I'll say yes.
Lynn?
Yes.
Alan?
Abstain.
How you abstain? Missing someone. Who did I pass over?
Josh.
Okay. I'm Elijah tonight.
Josh.
Okay, so what, and this is weird because I don't have it in print. What's the powers of the committee? What would be the powers of this committee?
You don't know.
I have no idea.
It's not clear. That's why I'm voting no.
I mean, like I said, if I don't understand it, I vote no.
Okay. The chair votes no. The motion passes 6-3-1.
The amendment passed?
Yeah.
Yes,
Okay.
it passed. Amendment 3. We got amendment 3 in section 1A, replace the
Are
phrase.
these amendments in writing in our package?
Yes, they're all in your packets. Please read
I
them.
found the first set. I didn't find it.
Under 7B.
And we've done those things.
We were out of time for the section, but should I get another 10 minutes on this?
Yeah.
7B. Motion 3 in section 1A, replace the phrase "if a complaint concerns the CA president or a board member other than the chair" with the following: if the complaint concerns the CA president, CEO, or a board member other than the chair, the complaint should be made directly to the chair of the CA board of directors until the ethics committee is established. Any such complaint against the CA director must be investigated. The amendment is made by Andy. Do I have a second?
Second.
A second by Bill. Andy, could you explain this one?
I just wanted to put in the language that we keep investigating until the ethics committee is established. I'll tell you the truth, I'm worried that we're not going to establish the ethics committee, that the board is just going to kind of, so I just put the language in.
Any further comments, Keith?
So I support language. The difficulty I have with some of these is that I support the general intent. The challenge that I have is, for instance, even with all the resolutions that we just passed on the ethics policy, realistically, I just went quickly through and looked at it, and it was a pretty, impressive job to systematically remove the ethics committee from the policy. So I'm hoping that these things that we're talking about would be temporary, but it sounds to me like it's being removed through the back end without that really being the justification. So I struggle a little bit with adding some of these.
Keith, what are you proposing?
I'm commenting on the piece here.
It sounded like you're proposing something. I was just.
Well, I didn't have to propose anything to discuss the amendment.
No, that's fine. I just thought you were trying to propose something.
Nope.
Okay, sorry, my mistake.
Nope. So I'm just stating that the difficulty with some of these pieces is that it's forgive me because you wrote it. It feels convoluted. But we have to stick something in there is what it feels like, because we've systematically taken the ethics committee that the board has approved out of everything else that we've discussed this evening. So, and again, back to the piece that we took out earlier this is for public record, so I can discuss that, but I think it's odd that we're in that position.
Dick?
I just have a problem with talking about things that are in the future. I think the direction the board is going is there will be an ethics committee, but to say this is what we're doing until we have an ethics committee, we don't have an ethics committee, we don't really have a PEO. I have a little problem with mentioning offices or organizations that don't exist. I mean, let's keep it to what exists, what we have. And I don't think the ethics committee thing has been lost. I'm pretty sure that the new board will be working in that direction. But let's not complicate things by talking about the future.
Ginny?
Yeah, this says must be investigated, right, Andy?
Yep.
I thought the process was, Chair, where you got complaints, and if you found that there was no reason to continue the investigation, it was frivolous, it made no sense, et cetera, that you have a right to make that judgment. The change that we demanded last year is you can't do that on your own, which has happened in the past. It had to go to the board, and you explain why. But then the board might decide to say it had to be investigated more, but it's not must be if there are no grounds. It's a total waste of time, money, et cetera. So I oppose this.
Any further comments on this amendment? I'll call the question. Al?
I have a question.
Okay, question.
So Andy, when you say must be investigated, it's unclear here to me what the scope of that investigation.
Well, you don't.
Pursuant to Ginny's question, could that investigation be that the chair of the board receives it, reads it, and says this is bogus?
No.
Yeah.
I'm asking Andy what the intent of his amendment is.
In essence, what I'd like is until we get an ethics committee formed, is that we take seriously any ethics complaints, and we do not just immediately say, oh, no, that we at least do a little bit of preliminary investigation where it says, is this really valid or anything? And you're right, you can come back, look, we looked at it, there's nothing to it.
That's our current policy.
No, that's not.
That's our current policy. Is
I thought I had the floor with a question with Andy.
Yeah.
I think he answered it. But
So yes, it is. You can
I
do
want to make sure we understand. So that when you say must be investigated, that investigation could be by the chair of the board to whom the complaint has been made. That would suffice. It doesn't have to be we're going to pay outside counsel.
No, it does not have to be. It's just a look. You have to. It has to at least be investigated. It comes back to the board for decision. And you're right. You could say, yeah, this is nonsense, or the facts don't support it.
Mr. Chairman, it would go back to the committee you already.
Yeah,
you just offered.
right.
This is about until the ethics committee is established.
So I've got
subset of the board that you just in the prior amendment.
Yeah, so we're out of time for this. So I think we need another 15 minutes. Dick?
There are, I think, 4, maybe 5 reasons why something can be dismissed. If, for example, the person's not around anymore, the thing was negligible, it wasn't really there wasn't a rule that it violated. I don't remember what they were, but there were some things for just shooting it down right away because it wasn't worth the time to look into. And the problem we had in the past was it was up to the board or to the vice chair of the audit board to make that decision arbitrarily. And so you had one person acting as judge and jury. And I thought we changed it to where that person could make a recommendation to the board that something be dropped or explored.
Did I just suggest that you may have used the wrong word, arbitrarily? I think you meant unilaterally.
Unilaterally.
Anyway,
you're right.
okay.
An English major should know that. And I'm just, I think where we are now is that somebody would, whoever is the initial designee would come to the board with a recommendation, not
any further
So call the question.
Any further comments, questions? I'll call the question. Lynn, how do you vote on this amendment?
I'm going to say yes.
Ginny?
No.
Josh?
I'm going to pass for now. Let me.
Alan?
Well, just to be clear, we haven't even talked about what the original wording is. The word talks about shall be considered by the full board of directors. That's what I would agree. That's what I'm going to say no.
Andy?
Yes.
Bill?
Yes.
Brian?
Yes.
Dick?
No.
Josh? Again? Keith?
Yes.
Josh now?
I'm going to say no because this does not require the complaint to be made to the attention of the board.
The chair votes no. The motion fails 5-5. Next, Andy, you got another amendment here. 7B amendment. Amendment 4.
Is this Amendment 5?
Amendment 4. Amendment 4. Andy's got like enough amendments to keep us here for the next, till the next board shows up.
12 minutes and 34 seconds.
Till the next board shows up, literally.
This is his job.
So yeah, Andy's going to keep this board busy till the last second of the year. But in section 1A, replace the phrase "if a complaint concerns the chair" with the following: "If the complaint concerns the chair of the CA board, the complaint shall be made directly to the chair or vice chair of the CA audit committee, and until the ethics committee is established, any such complaint against the chair or CA board of directors shall be investigated."
Point of information.
This must be.
When it says if a complaint
Must be
concerns the
investigated.
chair, ... is that meant to subsume the rest of that paragraph, or just that phrase, if a complaint concerns the chair?
It probably is the phrase.
Okay, the phrase.
Just the phrase,
Just the
not
phrase.
the whole paragraph.
Right.
With
Then
with
it
the.
doesn't make any sense.
Can I get a second on this? There being no second, the motion dies.
Yeah, we'll just go. Number 5.
Motion Amendment 5, add to the Section 2, Paragraph 1, if the complaint against the CA director concerns a federal or state item such as sex discrimination, age discrimination, religious discrimination, sexual harassment, retaliation, etc., the complaint must be investigated and does not need to be considered for investigation by the CA Board of Directors.
Just a quick, friendly amendment. There's a T in harassment.
That's fine. It's a editorial.
Okay.
How that's mean?
This is an amendment made by Andy. Do we have a second on it?
Second.
Second by Bill. Any questions on this? Seeing no questions, we'll call the question. Jenny, how do you vote? Any comments, discussions?
So here's what so what happens when there's a complaint of sexual harassment, sex discrimination against a director? What happens?
It gets investigated, according to this.
Okay, it gets investigated and
automatically.
And then what? I mean, that's where we have.
Then you go into the regular process.
Okay.
Josh, the purpose of I put this amendment in and why I particularly talked about federal or state type requirements is I do not want the board of directors to just on their own without any investigation dismiss a complaint.
No, I absolutely, I mean, if there
That's-
is an allegation, it absolutely must be investigated. I'm just.
Right. Well,
I'm just trying to figure out what happens, and that's.
It follows the normal process.
Okay.
Keith?
So, in this situation, can a director make an anonymous complaint about a director?
No. He already said they can't make an anonymous complaint.
We can make it.
So I guess I need to understand if that violates any federal laws or anything like that.
You want to weigh in, counsel?
Capacity as a director, if there's a sexual harassment, but you got a hotline, I assume, and
Yeah.
those go in anonymously. You don't want to alter that. But if you've got a board policy that assertions against, ethics complaints against other directors can't be made anonymously.
But remember that the complaint does not have to be made by a director.
Sure. Well, it has to be made by someone who witnessed the incident or was the
No, this is
victim.
against a director.
Against the director.
Yeah, it has to be made,
And this is
Right.
beyond ethics.
This is getting into
All right,
legal.
so I'd like to move to make an amendment.
Which the
I'd
amendment?
like to amend the motion. I'd like to amend the amendment and say to strike and does not need to be considered for investigation by the CA Board of Directors.
Okay, what does that leave us with?
That leaves us with if a complaint against a CA director concerns a federal or state item such as a sex discrimination, age discrimination, religious discrimination, sexual harassment, retaliation, etc. The complaint must be investigated. So that stays, and I just want to take out.
Andy, you accept that as a
I'll
friendly?
accept that.
Oh,
That's
that's
fine.
accepted.
All right.
So, Mr. Chairman, I didn't answer the question, which is a good one, which I don't know the answer to, which is it against the law to try to prohibit anyone with the organization from making an anonymous sexual harassment or other type of federally protected claim? I don't know the answer to that. I can certainly.
Alan?
A couple of things. I'm not sure what item means. I mean, I know what you tried to mean. I'm not sure that item is the right word. I defer to those who know what we're talking about. It's interesting to me that racial discrimination isn't mentioned.
I forgot to include it. Sorry.
And I worry a little bit about what et cetera means and where the limits of et cetera.
Racial discrimination is acceptable.
Well,
That's et cetera.
If it stops there, fine.
That's et
I
cetera.
think we would just include everything under 1983.
Yeah, I mean, against
We changed that
concern
from
for federal or
item to
state
law. Is that-
claim. I would be in favor of, and I'm not going to make this public amendment, I'd like to hear about it first, that we could say something like notwithstanding and refer back to whatever the decided that this could be made anonymously, because I think there are, even though there aren't reporting relationships among us as board members, there's still power relationships, societal power relationships that go beyond what we're talking about, and I think people ought to be protected in their anonymity there to the extent that that's appropriate by the law. And if we've taken out the part about investigation by the CA Board of Directors, then we don't have to worry about
Jenny?
one
Yeah.
director against another.
Oh, I'm sorry.
Go ahead.
Jenny?
I know we've dealt with something like this last year, but it says a federal or state item. I'm trying to figure out why is this under CA? Wouldn't that be automatically referred, or they would file with the appropriate federal or state agencies or county? Because it could be the county.
It absolutely could. I think it's just.
What?
I don't have a problem with us investigating. I guess my question, if we're hung up on this question of what's an item, could we just say, and I think the answer is, we could say any complaint concerning violations of the federal or state Civil Rights Act.
Okay.
Well, it could be county too, couldn't it?
Is there one? I wouldn't even. I'm
Yeah.
embarrassed to admit I
Yeah.
don't know if we have a
I
separate
sponsored it a
Okay.
long time ago.
federal,
Civil
county, or
rights bill.
state Civil Rights Acts.
Yeah.
Or is there
Why are we, what I'm getting at is, if in fact that, or allegedly occurred, wouldn't the individual be filing with the appropriate county, state, or federal agencies that deal with this issue?
Sure, they absolutely could. They would. You could have multiple avenues. If you are a victim of discrimination, you have multiple avenues, and just like you.
Bill?
Just on the wordsmithing that we're engaging at this late hour. Instead of item, I would just, for a friendly amendment, I would like to replace item with the word matter.
I'll call that it's fine. That's so replaced.
If it just clears up the discussion. And
any further questions or comments?
What I'm trying to get at is I don't know the expertise of this board to deal with that type of issue. I would think that it would be better handled.
We don't. I think we're just saying it's going to be investigated.
Okay.
And I'm assuming when we do an investigation, hopefully it never happens, but if it does and we investigate it, somebody will advise us.
I'll call the question.
Why don't you read what we have?
Add section 2, paragraph 1. If a complaint against the CA director concerns a federal or state matter such as sex discrimination, age discrimination, religious discrimination, sexual harassment, retaliation, etc., the complaint must be investigated, period.
Okay. I thought we changed it to say a matter involving a violation of the federal, state, or county Civil Rights Act.
We suggested that, but it was.
We suggested, but nobody wants it? Okay.
Motion or.
Yeah, I think we should do that. I'm with you.
Okay. On the motion, how do you vote, Alan?
What is the motion? Andy, did you accept that as a friendly amendment? You did.
Yes.
A matter, what was it?
Matter.
Violation of federal or state or county civil rights act.
Violation of federal, state, or county.
A matter
civil rights.
concerns a violation of federal, state, or county civil rights law. How do you vote,
Yes.
Alan?
Yes.
Jenny?
Yeah.
Dick?
Yeah.
Brian?
Yeah.
Bill?
Yes.
Andy?
Yes.
Josh?
Yes.
Keith?
Yes.
Lynn?
Yes.
Vote yes, the motion passes 10-0. Last one.
Point of information.
I'll withdraw.
Do we need to get a legal opinion to clarify whether our amendments conflict?
I will get that at the end.
Okay.
I'll withdraw number 6.
Number 6 is withdrawn.
Mr. Chairman, I have one final amendment.
What's your final amendment?
My final amendment is that upon passage of this ethics enforcement policy, the CA board directs the staff to engage the RFP process to create an ethics panel.
Do you need an RFP?
I think that gets us started.
Okay.
We should select a firm, and usually we'd use an RFP process to do that, right?
I don't think that's part of
the process?
though. I mean, or.
It's an amendment.
We have firms under contract that could do this, that already were subject to the RFP process.
So it sounds like you don't. So it sounds like you don't need an RFP for that. So that brings us to the main motion, and I'm going to ask.
So that hasn't been. Well, I'll second it so we can discuss it.
The RFP is not necessary.
I know, but
That's the amendment.
But he had a motion. A motion on the table. I second it so we can discuss it, right?
Right.
Yeah.
Okay.
Right? I mean, that's
I guess the question is, why do we need to have an RFP for a company where we already got an RFP for?
He wants to talk about it.
But you can talk about it.
Okay. Eric, I agree. I agree that we have companies that have gone through RFP that I'd like to make a friendly amendment to your amendment to remove the RFP process. Do you accept that?
I accept that.
Okay.
What's the motion?
So the question.
What's the motion, please?
Can you restate your motion so we can?
Upon passage of the enforcement policy, ethics enforcement policy, the board directs staff to engage a firm to begin writing the procedures for creating an ethics panel.
We could call it an
or ethics committee or whatever it is.
So the
Keith is.
So the question the question or the conversation that I'd like to better understand is, I believe that we've already passed this as a board and directed staff to move forward with that. So what I need clarity on is either what happened or why do we need to do it again? Something needs to occur, and then following that would be an explanation as to why it isn't already done.
Mr. Chairman, may I respond?
You can answer.
Okay. To the best of my recollection, in January, we accepted the recommendation that we should have an ethics panel. But following that recommendation, there has not been any direction from the board for staff to act on that recommendation. And that's what I'm attempting to do at this point.
Okay.
Dick? What we want is a recommendation from a law firm for the board. The way it was worded is they send us their policy and bam, that's it.
That's it. That's the way it's worded.
Well, I think we should make it clear that we get to review, or you get to review what that recommendation is from the law firm.
It just says it says upon passage of the ethics enforcement policy, the board directs staff to establish the ethics panel.
Well, that's ridiculous.
That's the motion.
I said engage a firm to write the procedures.
Okay, engage the
recommend
for an ethics panel.
To recommend procedures.
This is why I like these things ahead of time. Engage the firm to draft the procedures.
Yes.
You're just going to take it pig in a poke, whatever they come up with? You're not going to have any?
It's not my motion.
Draft is a draft.
Okay, well,
He's trying to make sure he's got the motion.
I'm just trying to get the motion direct. It's not my motion. Jenny.
Yeah, my concern with the Ethics Committee all along has been, what are we talking about? And we have not been very clear what exactly the implementation would be. So I don't see why we're attaching it to this, which is simply the code. The other thing is, if you direct somebody to do the procedures and the board has no say on, receiving it back, deciding whether that's what we want, I just think we're dealing with something that the next board should be dealing with so that they have more specifics. I don't see how I can't vote on it. I know that. It's not clear what we're actually talking about.
Alan.
The next board's going to deal with it anyway.
Right.
Why not I don't see any harm to getting the ball rolling. We did decide some months ago that we would have an ethics committee, and whether any of us individually agree with that or not, that's what the board decided. So I don't see any reason that it's about ethics, it's about enforcement of ethics. Where else would we put it but in an ethics enforcement policy? And the board will have a chance to decide to implement those recommendations or amend them as necessary. So
that should be in the resolution.
It's got to be. People can draft anything until the board passes it. It's not policy.
Yeah, well, that should be clear in there because the way it's worded,
that's how it is.
The way it's worded,
Okay. Anyway.
they're going to give us a policy.
Yeah.
I think it's easier to just vote this down.
Okay, so
trying to
Can we
clarify.
change it to a draft proposal?
I think I said draft.
You said draft a proposal. How about
Okay,
a draft proposal?
a draft proposal.
to be accepted, to be voted on by the board. How's that?
Yes.
Thank you. Okay, I'll call the question. Ginny, how do you vote?
No.
Andy?
Yes.
Dick?
No.
Bill?
Yes.
Alan?
Yes.
Brian?
Yes.
Josh?
Yes.
Keith? Keith?
Yes.
Lynn?
Yes.
I vote no. Motion passes 1, 2, 3, 4, 5, 6, 7 to 3. That brings us to the main motion. I'm going to actually make a point of information to the council. With all these amendments to what was originally a very simple change, with all the amendments, do any of these things actually conflict with each other? I'm
sorry, what?
So with all the amendments passed at 10:15 at night to this current motion, so right now we're back to the main motion to establish the revised version of the policy reporting for reporting code of ethics violations. With all the amendments that passed, do any of these amendments conflict with each other or conflict with the policy?
I can't answer that right now. I don't think there's terrible internal inconsistencies, But my understanding was that the task from a prior resolution was, once the code was passed, to tackle this for inconsistencies with the code and rewrite this policy altogether, and to contemplate an ethics.
So given that, and given that this whole conglomeration of stuff has not been reviewed, I'd move to table this motion.
Which motion?
Which motion?
The whole motion of 7B, the enforcement policy. Jackie?
So there have been a lot of moving parts, and staff is going to have to take all of the amendments that have passed and incorporate them in and figure out if there are any conflicts or contradictions, right? So I think you have two options. One is something that you discussed several months ago, which is along the lines of what Topper said. You developed and decided on a code of conduct, and it has passed, but it will take effect once there is an enforcement policy drafted that comports with that code. So that is something that had been talked about, but now we are talking about these amendments. The second option that I would suggest is you've made amendments to the enforcement policy. We need to do a review, incorporate it all in, make sure it's as intended, and determine if there are any contradictions and come back to the board with any questions. And until that time that we know there aren't any contradictions between the two documents, it just doesn't take effect yet. It can't, because we don't have something that we know works.
I would, so my suggestion, and I actually made the motion to table it pending review. So can I get a second on the motion to table? So I got on the motion to table.
Second.
And seconded by Ginny.
We're
tabling the entire.
7B.
No, we're tabling all. Yeah, tabling 7B.
That's it, just 7B. Okay.
So on the motion to, any discussion on tabling 7B, the ethics?
I would love to move it through and allow the second option to be considered, so that we can have something in place and that we can receive any conflicts back from that, because I'd rather approve something so that we can move forward here, and then we can always edit that in the future based upon staff and feedback.
Well, you're basically saying we could just approve.
No.
I mean, you're basically saying approve some mess and then hopefully get something back to approve again?
I sort of reject your characterization of what I said of this thing and everything that we've said as a mess. We just stepped through. But I think we feel reasonably comfortable with what we're looking to move forward with. We've had adequate conversation, and allowing an opportunity for that to be reconciled after we've approved it would be appropriate.
Dick?
Well,
thanks for listening.
I think this, yes, it's a little confusing, but it's a big improvement over where we were. And I think we need something in place. And I know this board, or the coming board, will jump into this thing and try to get the enforcement piece tidied up and perhaps get some outside comments. But let's have something in place that would replace Section 4 of the old code.
Section 4?
Remember we had a
fourth policy. So so you're not actually replacing, you're just editing it.
But taking what we've discussed with all the amendments, let's put it in place for now, so we have something there.
Bill?
Just a quick comment. It would have been refreshing to table this 70 minutes ago. I'm not sure.
I was actually hoping that Dennis didn't withdraw his table.
Well, what is going to be in place? The old?
Yeah, the old one.
The old enforcement?
The old enforcement policies.
Instead of this with the improvements.
I'm not, Josh.
And obviously, this is my last meeting, so I'm not, I guess, what happens going forward doesn't necessarily affect me. My overall comment that I want to make about this, and we've done a lot of work on this, and I'd rather we voted on it tonight. The thing is, ultimately, if you are a director of this board, you serve at the pleasure of 6 other directors. I mean, ultimately, if 6 other directors want you gone, you're gone. It's just that simple. No matter what we pass, no matter what the next board does. When 6 directors say you're done, you're done. And I think we've done a good job overall of trying to make, have these policies a little more concrete, a little more transparent, a little more fair. And I'd rather we voted on it tonight. I mean, ultimately, regardless of what opinions are proffered down the road, that's the cold hard reality of our enforcement mechanism.
Alan?
Maybe it's the time of day, but I'm not clear what the difference is between the two. So Keith, I'd like to ask you what it is that you'd like, be a little more clear, or what you see as the two, what you're not in favor of, what you are in favor of. That's not.
I agree with I agree with Josh, I guess with the caveat that there's some reconcilement that needs to occur, and just to give room for that reconcilement to occur. That's all. That's the only difference there.
So the choice is between tabling it all for any kind of vote. Staff, I guess if we table it, may or may not do all the reconciling because there's not something finally to look at. Yes, I think I would agree. Let's vote it in and see what the staff can move forward with the reconciliation, and then we can reconsider it if there's issues.
Call the question?
I'll call the question on tabling. Ginny, how do you vote on tabling?
Yeah.
Alan?
No.
Andy?
No.
Bill?
Yes.
Brian?
No.
Dick?
No.
Josh?
No.
Keith?
No.
Lynn?
No.
I vote yes, the motion fails 3-7 on tabling. So that brings us to the main motion of the edited enforcement policy with amendments. I'll be honest, I'm not even sure what the heck is in here at this point.
Yeah.
It's so convoluted that I couldn't tell you what the heck we're voting on.
I think it's pretty clear. We've been taking notes. We've made certain additions.
How is that different than all the ins and outs from the Code of Ethics? Why are these changes convoluted and you don't know what's in there? I'm not clear what's in the Code of Conduct right now, and these documents affect everyone in this organization.
I agree. And I just asked our counsel if there are any inconsistencies, and he couldn't answer.
How can any of us?
You didn't ask me that about the code.
No one asked that.
I'd like to call the question.
I will call the question.
So I did review the amendments that were presented to you in the materials before the meeting. There's nothing in there that's fatally inconsistent with the policy as it currently exists.
I'll call the question on the motion. Ginny, how do you vote?
Yes.
What's the motion to approve?
The motion is to approve approve the new ethics policy.
Thank you.
No.
I mean,
The new enforcement policy as amended.
As amended.
Ginny, how do you vote? Ginny votes yes.
Yes.
Andy?
Yes.
Alan?
Yes.
Bill?
No.
Brian?
Yes.
Dick?
Yes.
Josh?
Yes.
Keith?
Yes.
Lynn?
Yes.
Chair votes no. The motion passes 8-2.
Excuse me, can you clarify for us that with the reconciliation, until that takes place, that these two policies do not take effect yet because we don't know if they can work with each other and with the decisions made by the board in January? So can we get through that first?
No.
Well, right now, they're both in effect. So unless there's another motion to change so right now we approve to make them both into effect. Right. So unless there is a motion to suspend them, which I'll entertain.
You approved them. You did not approve when they are effective. And I am suggesting
my
that
comments prefacing the consideration of the code was that you were to consider that code, but it wouldn't actually go into effect until the enforcement policy was reviewed, a formal new enforcement policy presented to this board after the outside counsel drafted and worked with staff.
So what do you propose so right now we've got two past ethics code, two past policies. What do you propose for, what is it?
An interim, what works in the interim?
No. When does it take effect?
It takes effect immediately.
Right. Well, right now it takes effect immediately,
It's taken effect.
unless there's another motion to change that.
I will make a motion
Okay.
to suspend implementation of the recently approved at this meeting, Code of Conduct and Enforcement Policy pending legal and administrative review for conflicts.
Okay, I will second that motion. I'll also make a friendly amendment that that would have to come back to the board for a board vote to have it take effect.
I accept your amendment.
Okay, so we got a motion by Bill, a second by the chair, to suspend the implementation of these policies until it gets reviewed by council and comes back to the board for a vote.
Legal and administrative
Legal and
review for
administrative,
conflict.
yes. Legal and administrative review for conflict.
So I call it question.
Dick.
No, wait.
Well, I see this as just one more attempt to keep the board from doing its fiduciary responsibility to prepare an ethics policy and enforcement policy. And I'm a little disgusted that certain people just won't accept the fact that it's time to fix these policies.
Okay, Jenny?
Yeah. First of all, that amendment does not have a time certain in it, which means this could drag on forever. So that's one mistake. The second thing is there's no reason why, and I understand where you're coming from, but there's no reason why it cannot be effective immediately, which is usually the way this board operates, as opposed to a legislative body, which has a specific date for implementation. But there's no reason why we can't get an opinion, or the next board, if you find something, they can easily amend it. That's what it's all about. So if you really find something serious, it's presented to the new board, and they come up with an amendment if, in fact, they agree with you. No big deal.
So I'd prefer to find these things before they get implemented.
Well, yeah,
That's my preference.
Call the question.
Well, I can get in the queue too.
Let's call the question.
Josh.
Again, ultimately, if we have to go through this, if we have a violation of this policy, ultimately, if there is something that's inconsistent, that we ultimately have to vote on what we're going to do about the offending party. And that at that time count if there's a contradiction, if there's something that is impossible to square with the code or the law. That's something that I'm sure our council will bring to our attention at that time. So there's been this mantra for going on 12 months now that we have no ethics policy. So I mean, this can be but that's what people have been saying.
Well, there's nothing in this revised policy. Nothing would be violating this revised policy that wouldn't be violating the policies that are currently.
All right, that's fine.
The mantra was to simplify them, clean them up, make them easier to read, not to alter substance, and that's where we are.
Okay, yeah. I mean, I'd rather see this implemented, and if there's something unjust or unlawful about it, I'm sure that'll be considered when we have to just,
But I'm suggesting that as a reason not to.
Okay.
Okay. Keith?
So the first concern that I have with the motion is that everything that we just struggled through, literally by this one motion, can be undone, because by accepting the friendly amendment from Eric, essentially what we just did is we said that we have to bring this whole thing back to the board for approval, which means we're going to start this whole thing over again. And we've done all of this work for naught, essentially, because we're going to be debating about these things over and over. So I would like to recommend a friendly amendment to the friendly amendment that states that we implement immediately and only bring modifications that are in conflict back to the board for approval. That way, what we're looking at is we've got an ethics policy and an enforcement policy that are going live. We're sending it back for review. And if we find things in that review that are in conflict, then we can bring those elements back to the board for approval. Not the whole policy, but those items.
I don't accept that because I see the ethics policy as a car that you drive, and I want to make sure that the car I'm driving before I get in the car and drive it is safe versus driving a car and then finding out 10 miles down the road that all the wheels fall off. So that's the analogy I use. So I don't really want to get in the car right now and then have it come back that says this is broken. So I do not accept the friendly amendment. Ellen?
Question, I absolutely agree with Keith. If I was to use that analogy, to me, the ethics policy is the rules of the road. And I think of it every time I drive up Harper's Farm Road, where the speed limit says 35, going from my house toward the village center, but coming back from the village center, it says 30. And so it doesn't say where the one ends and one begins, so if I ever got stopped, I know I'd make that argument, but that doesn't stop me from driving safely, and I would get adjudicated at the time it needs to get adjudicated. So I think what I would like to see us do is ask the staff, it's here, ask the staff to do they got to create the clean version, review it for any inconsistencies and report those back, but it's not about asking the next board to reopen the whole thing. What do we want? Do we like the policy? Don't we? It's just about inconsistencies. That's what I would think.
My last comment about it is with the analogy, which I think is a good one, but I want to take it a little bit further based upon what we've heard. We've got a vehicle that is roadworthy at this point. To all extents, we've been told that based upon the amendments that've been read, that there are no major issues. What we're talking about is if there's a recall. And if there's a recall on the vehicle, I want to know about the recall because I want to immediately go in and make adjustments to that vehicle to ensure that my airbag is going to work and that things are functioning the way it is. But it's already passed all of the inspections and things that need to be passed in order for it to be roadworthy. And that's what I'd like to see us do rather than unwind this whole process.
We'll take a vote.
I'll take a vote on the motion to suspend the implementation of the ethics policy pending further legal administrative review and board vote. Jenny, how do you vote?
Abstain.
Brian?
No.
Bill?
Yes.
Andy?
No.
Ellen?
No.
Dick?
No.
Josh?
No.
Keith?
No.
Lynn?
No.
I vote yes. The motion fails 7-1. Okay, that brings us to we're between motions. What could you possibly be asking?
Motion.
For what?
That we ask the staff to check and review the policies as we have created them for inconsistencies and to bring those.
We don't need a motion. They'll do that. We don't need a motion to do that. They'll do that.
Staff will do that, right?
Staff will do that.
Yes, sir.
We don't need a motion for that.
Like the ethics committee?
What?
That's for the next board.
That's for the next board.
No, I meant like the ethics committee. We passed something and we said staff was going to do it, but it
that passed 7-3. The ethics.
But it never happened. That was back in January.
That's right.
It hasn't happened.
It's passed. It passed. That passed tonight. Good.
It did pass tonight. But we also voted on it.
Very good. I'm fine.
Okay.
I withdraw my.
Let's move on.
Okay. The chair moves to add $3 million of FY23 to the cash reserve fund. Do I have a second?
Second.
Second by Dick. Any discussion?
I have a 17-point question.
I'd love to hear your 17-point question.
Want to be attacked?
I only have a one-point answer. You want to see it?
Forgetting.
Get a little punchy, my apologies, I would.
Thank you.
Well, you didn't have 3 million.
And any further questions?
No.
I actually do have some questions on this, so.
Thank our guests.
What? I've got a question.
Thank you.
Thanks for.
Thank you,
this.
Doc.
Thank you.
Appreciate it.
Where's my packet?
Was it ever,
So yeah, I've got a couple questions for Susan on this. So back when we first passed the cash reserves, the target for this year was $5.1 million. And now the update for the end of this year. And now we got to the end of this year and the target for the cash reserves has gone from 5.1 to 7.4.
Right.
So the question I have is why did the target shift by 40%?
Because the expenses of the organization grew.
By 40%?
Sorry?
By 40%?
Yes.
Or expenses grew by 40%?
I'd have to look at the budget.
That's
It sounds high, but I don't know.
That is a
So,
huge.
Susie, are you saying the expenses year to year increased by 40%?
So let me see. I think I thought that was the only thing that I changed was the budgeted expenses.
Yeah.
From, it's 2 years actually. It was the 22 estimate and I used the 24 budget.
Well,
originally. So the previous target was based on the FY22 estimate, and this time I used the FY24 budget.
So our target balance at the beginning of the year was 5.1, and now it's 7.4. So that's a 40% increase.
Right, I just explained why.
And you're saying that our expenses
Over 2 years.
increased by 40%?
I did not bring that with me, but I know the numbers were correct when I prepared this, and we discussed it 2 weeks ago, and there were no changes made.
So while I don't have numbers in front of me, so I can't give you specifics, I will tell you that coming out of COVID, my operations have increased dramatically, and so have the revenues. Accordingly, that's why we have exceeded budget. So yes, there has been tremendous growth both above and below the line in the last 2 years. Because remember, FY22, we were just starting to come out of the pandemic.
In FY22, we only opened 16 pools.
Yeah, so there's been tremendous operational changes in the last 2 years.
Right.
Well, that might be the case for sports and fitness, but we're a fairly large $70 million organization. I don't think the organization went from
So we
40 million to 70
Open
million.
space was not 100% either.
Right, and nor was, none of the organization was, and so these numbers are correct. I did not change them from 2 weeks ago till now.
No, not.
So if I was not prepared to discuss that because it had been discussed 2 weeks ago in detail, and I do not have those numbers in front of me, but they were correct.
No, I'm not disagreeing with the numbers. I'm more kind of scared to see expenses jump 40%.
Well, revenue increased dramatically as well, so I don't know that you could. And you approved the budget for 24, so that's what this is based on.
Okay. And the
COVID budget before, so there is going to be.
Oh, that's a COVID budget. So this is based on the COVID budget. And the other question I have is why are we overfunding the target?
So we didn't have any targeted funds planned for FY23. There was no addition planned. So this is an opportunity because the dollars are available to add dollars. There was not another funding increase until next year. So there were a couple years where we didn't foresee being able to fund, to add any funds to the reserves.
So we're actually.
So if you look, we're still, we're spreading out because this is difficult for the organization and because the organization in 55 years has never had a cash reserves, we spread out the full funding of this over 6 fiscal years. So this is already spread out too long, right? And this addition of adding 3 million, to this still only brings us to less than half of the full target of what the organization needs. 6 months of cash reserves, it would be $30 million. And we're nowhere near close to that, and yet that's what many other organizations have. So,
6 months of cash reserves?
yes, the villages all have that amount, so.
And that was a policy that was passed by the board to create that fund of 6 months.
No, I realize that. Yeah, Dick?
We have the money, and we need to fill this bucket. So I don't know why there's a fuss here. Let's just do it.
I guess the question I have is, are there other priorities that we should be considering as a board?
This is out of this year's budget, right?
Correct.
Yeah.
And
So
it's
you have-
done. I mean, this year is over in a couple of days.
Over tomorrow, essentially.
And let's take the money that we have left over from this budget and put it in our reserve funds which is what we all plan to do. I don't see why there's any discussion.
Well, we've already put $3 million.
talked about
We already put $3 million from this year in the reserve funds. This is an additional $3 million.
Yes, and why not? I mean, it's too late to build a new tennis court. I mean,
I'm sorry, you put $3 million in last year.
I thought we put $3 million in for this fiscal year.
What did we vote?
No, FY22.
There's $3 million from FY22 and also $2 million from FY21. Wait a second.
Right, and this is FY23.
We put $3 million. I thought the $3 million was from the FY23 budget. We didn't have $3 million in the FY23 budget. Didn't we have $3 million allocated in the FY23 budget?
No,
We didn't.
no. That's my point. That's the point of why, right.
Okay.
to call the question.
I'll call the question. On the motion to add $3 million to the cash reserves, Alan, how do you vote?
Yes.
Andy?
Yes.
Bill?
Yes.
Brian?
Yes.
Dick?
Yes.
Jenny?
Yeah.
Josh?
Yes.
Keith?
Yeah.
Lynn?
Yes.
I'll abstain. Motion passes 901. Next, the
CA board operator.
move to establish a oversight committee who will be responsible for the FY24 for leading the selection committee for the next permanent CEO, and establish a strategic committee who will be responsible in FY24 for leading the process for establishing the next 5-year strategic plan. The chair moves. Can I get a second on establishing these two committees?
Second.
Jenny seconds. Are there any discussion? Seeing no discussion.
Does this come with charters, or is this just?
Right now, this is establishing two committees to do these two things.
And that's all we're going to do tonight?
That's what's on the motion.
Yeah.
And there's no timeline.
No timeline. It's just that's establishing two committees to do two things.
That's it.
Keith.
So since there's no timeline, so the reason why these committees were being formed, is, as I understood it, is so that when they move to, so when the new board comes on, we can immediately start filling those seats and taking action. So if we're approving committees that have no timeline and have no sense of charter, then we're really defeating the purpose of establishing the committees prior to the new board coming on board.
They have a purpose. I mean, one committee is to select the next permanent CEO, and the other committee is to establish the strategic plan, the 5-year strategic plan. So they do have a purpose.
Right.
Okay.
And the charters have been drafted, and that's for discussion by the next board as to, whether those charters are appropriate or not.
Jenny?
Yeah, and I think the main point that we were trying to accomplish was, should this board continue to function as a 10-member board, or should it have committees? And this is just the first step in terms of it's two committees, and this is the main function. And then the next board will put more meat on the skeleton, or however you want to look at it, because they may have different opinions of what should go under each committee, but at least get something going. And that was the only intent as far as I understood.
So if these committees are in lieu of the work session, if that's the intent, there is a pretty big lift on the part of staff. I've talked to IT about what it would take to do 2 live stream meetings at the same time, the packet that has to go out, the meeting minutes. I don't know that we would be able to, and that's why I asked about the timetable. I don't know that we would be able to manage that lift until probably sometime in the early fall. So May is a lost month. It's administrative, it's organizational. And then June, there's other things going on. July, you meet, but then August is off.
Right.
So sometime September, October-ish. But it's not a minimal. Now, of course, it depends on how much the agenda changes over time. But it's a pretty big lift. I know that Janet and Julia were here last night until 8 p.m. And you think that it's easy to just move something. It's not.
Bill?
I'd just like a clarification. Is this just the naming of 2 committees, or does this carry all of this, simultaneous meetings, assignments, and charters, and what is on the table here?
Right now, it's creating right now, it's exactly what it says, creating 2 committees, one to establish the strategic plan and the other to the CEO search. I would recommend that.
Neither is doing that. It's about creating processes to do that.
Yes, to do the processes, yes. I would recommend that, so everybody has an equal chance that 5 on one, 5 on the other, they meet separately at the same time. But right now, it's just establishing the 2 committees and giving them a chart for an objective for FY24.
Okay. So call the question.
I'll call the question.
Got my hand up. All right.
Alan.
Provision on your left is not always there. I'd like to know, is there anything in our policy or state law that says we have to live stream committee meetings? Or is that just something we can do?
No, we
find out, but I don't.
We don't live stream all our committee meetings. Like our audit committee
The
public
committee
meetings.
meetings as a public meeting might be different than if it's just a.
Like our audit committees aren't live streamed.
True, you're right.
Well, but we can make any committee be on Zoom, for example, and people can come.
So it's not only, it's true, but it's managing the process. Is it hybrid? Can people attend in person and on Zoom? And then who manages getting people into the room?
Yeah.
Which is why just having it on Zoom might make
Which I prefer. We would prefer that.
Anyway, I'll call
Just
Andy.
Get a clarification question. I mean, I got to admit, the committee, the motion is really vague on what these committees do. I mean, are we in essence giving the selection committee the right to choose the president?
No.
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 To create the process. For leading the process.
It always, the board is the one
Yeah,
that has to do it.
the board has to do that.
Yeah, I mean, that would not go over.
Yeah, these committees are just putting material out for the board to vote on. I'm not even sure if
It's
they're.
like the subcommittee we set up in the last process. Went to the board made the final decision.
So yeah, but we gave them more direction. That's the problem.
Yeah, well,
Well, hopefully get more direction over time.
Keith has his hand.
Keith?
So I just want to make sure, because what we're saying is different than what's on the document, because it says that they're going to undertake 2 major initiatives in the upcoming fiscal year. One is update the strategic plan.
Yes.
It doesn't say discuss process. It says update of the Columbia Association.
This motion says for leading the process for establishing the next 5-year strategic plan. That's what the motion says. So the motion is to move to establish an oversight committee who will be responsible in FY24 for leading the selection process, not doing the selection, leading the process for the next permanent CEO, and establish a strategic committee who will be responsible for leading the process for establishing the next 5-year strategic plan.
Sorry, I was reading the document before that.
It's a motion.
I get it, but I was just reading the supporting information that comes.
Okay, can I call the question?
That's why I asked.
I'll call the question. Alan?
Yes.
Andy?
No.
Bill?
No.
Brian?
Yes.
Dick?
Yeah.
Ginny?
yes.
Josh?
Yes.
Keith?
No.
Lynn?
Yes.
I vote yes. The motion passes 7-3. Next one, CA advisory.
A point of information around that. since the motion is different than the supporting information, does the other information that is in the memo, is that accurate as to how this is going to operate?
It's supporting information. Basically, that can be used going forward to establish charters.
I'd say that's for the next board.
That's for the next board. 7E, I'm just going to do these in order. I'm going to move to remove the appointed board member liaisons from all advisory committees. So at the end of last year, we removed them from 4 of the advisory committees. So I'm going to move to remove the board liaisons from all the rest of the advisory committees. Can I get a second on the motion? Seeing no second, I'll try option 2. I'm going to move to add board member liaisons to aquatics, golf, health and fitness, and tennis advisory committees.
Second.
Ginny got it first.
Move.
I moved. Ginny got it first. Any discussion on re-adding the liaisons to aquatics, golf, health and fitness, and tennis?
Yeah, just a quick comment.
Okay.
In the report, it makes it clear that advisory committees ensure that there is a substantial level of community participation and involvement in the development of CA programs, policies, and priorities. I just have a lot of respect for the advisory committees. I think we set them up. We should be listening to them. To the extent a board member wants to attend, you can't, I think Keith's concern was, have to attend all these? No, and some board members are willing to take on more than one committee, 2, 3. I had 3 one year, 2 last year. It's not that you have to be assigned to that committee, but it is an option. But we've got testimony from all those committees that didn't like this report because they said, we want you there, we really appreciate it. So the chairs of those committees kept saying, we want the board members involved. Now, can you force a board member or can you get a board member that's enthusiastic? That's a whole different issue.
Okay, thanks.
But it's just respecting the committees.
Can I call the question?
I have my hand up. I just wanted to ask the question. So with doing this, what's the implication of us not being able to place a board member? So let's say that, we've got strategic, we've got operations, we've got BOC, we've got IAT, and a board member decides that they're not interested or able to sit on a committee. So is someone going to assign that, or are we going to pass on that specific committee assignment?
The way it works is the chair makes all the decisions. So board members typically express interest in advisory committees, and the chair will make the appointments as people express interest.
I'm just trying to understand if there's one where someone doesn't want to sit on it, how do we handle that? Since we're requiring.
Well, no. So if there's a committee where no one wants to, perhaps the chair either steps in or maybe no one steps in, but I can't really force someone to show up. Alan?
I think your vote for the next chair will be influenced by that.
A liaison is a little vague. It doesn't necessarily mean that person has to attend every meeting of that advisory committee.
Okay.
They could talk to the chair. They could talk to the staff person who signed to that. There's various ways that person could do that. And in the past, as Ginny said, sometimes another board member will step in and take the next board duty. And just because somebody is assigned to liaise, or if they don't liaise,
No one's gonna knock on your door if you miss a meeting.
Yeah, and the 2 committees that were just set up, you can't really use those as examples because in the past, the whole board would be dealing with that, so everybody would be dealing with it. So,
All right, can I call the question?
yeah.
Alan?
Yes.
Andy?
No.
Bill?
No.
Brian?
Yes.
Dick?
Yeah.
Ginny?
Yes.
Josh?
Yes.
Keith?
No.
Lynn?
Yes.
I vote yes. The motion passes 7-3. So that brings us to questions only. Please, no questions. You have to have a question at 11 o'clock at night. You got 10 minutes then.
2 questions. It was asked, mentioned in resident speak out about water quality reports.
I suspect that during pandemic, we don't have them. 20, 21, and 22.
There was also the suggestion that dams make dredging necessary. Do you have any off-the-cuff?
Yeah,
What would happen if we didn't
so
have it?
sediment drops out of water when the velocity slows down. Think about a stream. It's, a fast-moving stream. It carries sediment in it. As that stream hits a body of water, it slows down and the sediment drops. And of course, the lighter sediment travels further, and likely you would get some of the lighter sediment to drop over the dam, but you're not going to get all the sediment to continue on downstream. So I would
If we
say
didn't have a dam, we wouldn't have Lake Elkhorn, is that correct?
that's true.
Yes.
So, an option, I'm not proposing it. We could say these people-made lakes are
Yeah, man-made lakes.
problem.
They absolutely are.
But if we didn't,
They're also a great amenity.
but if we didn't,
More problem than they're worth, so if there's a worth, we could think about that.
but if we didn't have the lakes, the water has to go somewhere, which could be in someone else's basement.
Chesapeake Bay.
But
Into the Chesapeake Bay.
gotta go somewhere.
Thank you.
It's also got to get there somehow, which could be through someone's basement. Ginny.
Yeah, just a quick thing. I'd like to congratulate your staff, Julia, and also the IT staff for an excellent job. This is Brian's baby, in making it easier for the CA board to communicate with the staff and then turning it, and I'm sure this wasn't easy, into a, whatever she calls it, a smart chart or something. I'm very impressed, and I know it wasn't easy. So if you could pass that on, at least from me, to the IT and to Julia.
Will do.
It probably was a nightmare.
Any further questions? Seeing no questions.
Are we the legal issue of the anonymity, is that definitively getting, you said you were going to cover that at the end of the meeting?
That's already, that's already in the, it's already in the.
No, I'm just wondering about, did that amendment pass with
Yeah,
all
it
the
passed.
crazy?
Yes.
Okay, so if the, not the anonymous amendment, but the amendment that you added for the civil rights.
Yes.
Yes,
blah, blah,
that
blah.
passed, yes.
That
Yes,
passed,
yes.
but following that, you kind of moved on when we were talking about it and said you were going to deal with it, but later, which is the legal aspect of can we, and I know we're dealing with, we said we're going to ask them to look at the pieces, but the legal aspect of an anonymous complaint on a federal or state.
I don't answer legal questions. It's not my job. I'm not a lawyer.
Okay, let me try again. I brought it up and I was looking for a response. You dismissed it and said that I'm already going to deal with that later on in the meeting. It's later on in the meeting, and I'm just asking, are you going to address that as part of later on in the meeting? For the public record. That's what I'm trying to understand.
So right now, legal counsel's gone.
Oh, goodness gracious.
And that can go to legal counsel.
I just want to make sure that things don't get lost, because if I have a concern at the board meeting and it just sits out here.
I'll address it this way. Dennis, please bring that to legal counsel for a
That's
response.
perfect. That's all I want to know.
That's all we need to do.
Yeah.
Thank you.
Thank you.
We good? Okay. Proposed new topics. Any proposed new topics for the next 3 days? Nope. Good. That leaves me with chair remarks, I believe, if I remember the agenda correctly. And I'd like to thank you all for a long meeting. I'd also like to thank you all for a really good year. I think we've actually had a lot of challenges, but we got through them. And to all the returning board members, we've got two big priorities coming up, the strategic plan and the CEO search. And I'd also like to thank our leaving board members. So Josh, I know you're a short timer, but your wisdom and insights are very greatly appreciated.
My pleasure.
Dick, thank you for all your help drafting the ethics policy. It's been many
Dennis, thank you
moons
for approving it.
in development. Brian, thank you for all your work on the environmental concerns and open space. I know you're a champion. You're certainly a champion of our open space, and that's really important. And certainly keep up the good work championing for our open space. And Ginny, thank you for serving as vice chair. I could not have gone through this without you.
Thank you.
Yes, this is the first board I've chaired, and your advice has been phenomenal.
It's been fun.
And lastly, Dennis, this is a challenging role. Thank you for stepping up.
Yeah.
It's been interesting.
It's been interesting. It's challenging, but I think I'm going to speak for the board, but I think we're really happy with the way things are going, and we're really happy working with you.
Yeah, thank you, Dennis.
Thank you. With that, can I get a motion to
So moved.
adjourn? And second, seeing no objection, meeting's adjourned.
Is it too late for you guys?
Come over.
Yeah.